Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And with me today is Uncivil Law. How are you doing, sir?
I'm very happy to be back. I'm feeling very good. Glad to be here.
Great.
Everything's great.
I'm looking forward to today's show. I've been learning more and more about you as time goes on, and all good things. Like your well, we have a shared affection for a certain YouTube lawyer that we kind of briefly discussed by the name of Devin.
Yes. I like to whisper it softly. Dusimo.
So we might have to touch on legal a little bit. As cancerous as touching on legal can be, we might have to talk about him just a little bit, because I had a meltdown the other day because and it's your fault. It's entirely your fault. Like, I don't sit around watching his stuff because it annoys me, but I was watching your video and you watched his thing, so I had to watch it vicariously.
Yes.
And then I decided that I had some things to say as well. And so that
I am so sorry. You know, you could have stayed blissfully ignorant, and I exposed you, and then the rage came forth.
It did.
That was my fault.
Yeah, it was not good. And by not good, I mean it was just Legal's normal content. So there was that. We do have some other topics to talk about. Well, I do know that we have a mildly different opinion maybe on Floyd. I don't know if it's that different. I think you might just be a little more optimistic of chances on Murder 2 than me. But that's okay. I figured we could talk about that. And then I watched your show today about the transgender rights, respecting the transgender's rights of a 4-month-old.
Of a 4-month-old. Yeah, that was all kinds of special. Yeah, the transgender rights of a 4-month-old from Washington State federal court. And you're just reading it, and like, what the hell is this?
You're going, we are here, aren't we? We're actually here doing this right now. This is a thing that's happening. We're talking about the hypothetical potentiality of a potential transgender 4-month-old with
no, it's child services in their infinite wisdom trying to prevent this couple from adopting their own great-granddaughter. It's their own great-granddaughter, and they're preventing them from adopting it because they don't pass the LGBTQ questions. And some of the questions that child services asked are just so great. You know, all these on the record questions, because they're in the court case. They asked these questions: how would you react if your 4-month-old great-granddaughter was a lesbian?
Well, I would keep her away from the intimate parts of other 4-month-old children. I would think.
Would you allow your 4-month-old great-granddaughter to have a girl spend the night at your home as being part of being a romantic partner? What kind of question is this?
That was a wild question in general, because I wouldn't let my 15, 16-year-old hetero kid have a hetero member
apparently that was also the wrong answer to the question implicitly.
Yeah. It's like,
apparently you're supposed to let your teenage child shack up with them in your own home,
right?
And if you're not, you're a bigot of some kind. You're not sex positive or something.
Respect their sex rights, bigot.
And it's like, you can't make it up. The court just quotes these literal questions in quote marks. It's like, you can't believe you're reading it.
So we're gonna get into that case because I know some people who will be watching tonight may not have seen your video, and they should check it out, because I was just chuckling. I was making myself dinner. I don't know about you. This is completely off of any legal topic, but the older I get, the weirder my food ingestion is. So I don't eat for an entire day until it's like 9. And then I eat a catastrophic amount of food. And then I try not to fall asleep before this show. That's my entire schedule now. So I was working on stuff, for this. I have a rare instance where I have to be a real lawyer coming up in a couple days. So I was working on that. And then I also was just helping my wife out with projects around the house. And I realized after hanging a big, like, giant shelf that I was really, really tired. And I'm like, oh my God, I got to eat. So I went up to my kitchen to make some, I used a blend of leftover soup, but my kids ate all the noodles because they're jerks. So I had to make some noodles and heat up the soup or whatever. And so I was listening to your video. And I was just cracking up because you're like reading through this stuff and mentioning just how weird it is that they just seem to have left out the idea of respecting the integrity of religion of foster parents.
Yeah, no, I love that. It's like, what thing is normally in this list that's conspicuously absent from the list? Religion. Yeah, that's good. Yeah, it was one of the more depressing cases I've had the occasion to cover on my channel.
Yeah,
it's like the fevered dream of the conservatives circa like 5 or 10 months ago, or 5 or 10 years ago.
I mean,
it's the fevered fantasy nightmare that, the right was mocked at for suggesting this could ever happen when transgender rights were being discussed. It's like, oh, we just want you to recognize our rights. We're not coming after you and your family. I'm like, I'm reading this case and I'm like, I think we might be there.
It's like, we don't have a slippery slope argument. We have an oiled inclined plane to a flipping cliff.
There was the re-education. Don't forget the re-education.
Right.
Because they gave them the wrong answer. So the government has to re-educate you, don't you know? So they sent them pamphlets and statistics and brochures and things so that they could be re-educated, so that they could have a more informed opinion, I believe were the words used by the court. Informed opinion on transgender issues.
Yeah.
That's just great.
We'll get into all of that as well. That's kind of our second topic. I only have 3 topics listed, but there are more. Sure. And we have SCOTUS. Some big SCOTUS stuff happening today with the vote. Pennsylvania and North Carolina getting conflicting. Well, they're not really conflicting rulings, but apparently conflicting rulings from Wisconsin. And then I wanted to ask your opinion because on a constitutional issue, because sure. I think I'm right. Now, logically, I always think I'm right. That's how we work. I wouldn't have an opinion if I thought it was wrong. But I'm open to an alternative perspective, and it is about the right of state legislatures to allow early and absentee voting. Because I was in an argument in my comments, which is always a smart thing to do.
Oh yeah, no.
With someone who suggested that early voting violated Article 2, Section 1, Clause 2 of the Constitution, which is I know you know it off the top of your head verbatim, but in case you don't remember,
I'm pulling it up as we speak just to make sure I have it in front of it.
It's you thief.
I'm feeling something that was written. It's public domain. From
not you.
Okay.
Sorry, my Maoist wife redistributing my EL fudge cookies to her. Ridiculous. No, so it's the right. It's basically lays out that state legislatures establish the manner in which electors are chosen, and then that the federal Congress may set a date for the electors to cast their votes. And the person was arguing with me that early voting violates that clause of the Constitution, because if Congress sets the day for the election, for the general election, that is the only day on which votes could be cast. And I think that is a misread of that clause of the Constitution.
Yeah, so Congress can determine the time of choosing the electors on the day which they give their votes, which shall be the same day throughout the United States. So the electors are, of course, the electors for the Electoral College,
Right.
which are the ones that are casting the electoral college votes. So those all have to be on the same day. So if we're talking about
Which is in December.
Absentee or mail-in ballots for electors, then probably no, that doesn't make any sense. But I don't see how that clause really speaks to anything other than the electors.
Right, and if you notice, they do the time of choosing electors, which is capitalized, and the day that they shall cast their votes is capitalized, and then the day in the next clause where it says that day shall be the same or whatever.
Right.
I believe that that's a callback specifically to the capitalized day. I don't think that they're saying day and time are necessarily the same day, but this person was arguing that they were. And I was like, well, when you write statutes and contracts, if you're capitalizing, you're typically setting up a defined term. And so by going with two capitalized days there, I think they're actually calling that a specific thing, and time would be distinct from that, is kind of how I read it.
Well, I mean, even beyond that, when you're just thinking about reading language, when you're using the same word in the same, sentence or same, breadth, as it were, then you're interpreting the same. You use the same word to mean the same word, and different words to mean different words.
Right.
So if you're saying time and day, those are distinct words, so presumably they have distinct meanings. And if you're using the word day in the same exact clause, presumably it has the same meaning twice because it's the same word.
Right.
So that just seems like normal construction.
Yeah, I agree.
I think your commenter might have been wrong.
I think they were maybe misguided by something. I don't like to say that someone who maybe a lay person might be, like they might be wrong, but they might have gotten bad information from somewhere. So I mean, they're wrong, but not because like they reasoned it out to be wrong. I think maybe they got a bad lead. Maybe they got a bad lead.
And
anyway,
there's also a clause in there somewhere. I was trying to find it where it basically talks about the rules for elections or for the House, where it says that
that's
the states
an article.
can make those decisions.
Yeah, that's Article 1.
Yeah, I knew. I was trying to find it. I knew it's not there somewhere.
I don't remember. I've got my pocket Constitution here. I could look at. Do you have one of these? Do you have one? Have you met a militiaman to give you a pocket Constitution? Where is it? Article 1, section. It's gonna be section 2. Here, I'm guessing. Let's see. The actual enumeration, terms, blah, 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 blah. Oh, crap. Does it have it? Is it in section 2? I don't see it here.
I'm trying to speed read the Constitution.
Section 4, Article 1, Section 4. Times, place, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. Congress shall assemble at least once in every year, and such meeting shall be on the first Monday in December, unless they shall by law appoint a different day. So that's it.
So I think a lot of the stuff from the same Supreme Court, their judgments are coming at least partly from this, because the time, place, manner of holding elections for senators and representatives are chosen by the states. So if the state, and this is also from Bush versus Gore, that and federal preemption from Perel basically says that, you let the states do what they want. The federal courts shouldn't intervene. That's Perel near an election. And you just let them go. So if a individual state wants to extend or modify its own internal rules, that's probably going to be okay because of that kind of language. So that seems to be where a lot of this is being driven from the Supreme Court's jurisprudence, as far as I can tell.
And I think people don't understand just how much power the states have to do this. You are not. Not you, but general you are not guaranteed any right to vote at all. In fact, if our states were to pass a law that they will choose the electors by appointment from the legislature, that's actually upheld in a case law. It's still good law from, I think, 1869. So we've got a post-Reconstruction law. And they've said, that while many states have, because states at that time were choosing their electors by district. rather than general elections. A couple of them. Most of the states had moved to general elections, but they were actually appointing legislatures or electors by district, and they were sued, or they sued under the idea that everybody should be one person, one vote, so commonly said, and the Supreme Court's like, nah. You don't have to do. If the state legislature doesn't want to do that, they don't have to. But if they do a vote, you can't be deprived the right to vote based on your race, which is, of course, the 15th Amendment.
Yeah, I'll just quote two sentences from Bush versus Gore 2000 that makes this point exactly. So this is from Bush versus Gore. Quote, the individual citizen has no federal constitutional right to vote for electors for president of the United States unless and until the state legislature chooses a statewide election as the means to implement its power to appoint members of the Electoral College. And then later in the same paragraph, it says, the state, of course, after granting the franchise in the special context of Article 2, can take back the power to appoint electors. There is no doubt of the right of legislature to resume the power at any time, for it can be neither taken away nor abdicated. So they can give you the right to vote and then say, no, not so much. We don't like what you said. We're going to change your mind, change our votes.
Yes. Yes. It's great. It's, it's crazy because the way popular media talks about this and the way, everybody talks about it is this idea that your vote is some sacrosanct right on par with your right to speech, your right to bear arms, your right not to have soldiers in your house, all of those things. It's actually nowhere even close in the framer's mind to being that important. Your right to vote is far less important than your enumerated rights in the Bill of Rights. It's far less important than your natural rights to life, liberty, and the pursuit of happiness as well. So it's I don't know how we change the dialogue on that. I don't think it's possible.
I want to say it was Justice Kagan when she was giving some remarks to the Senate Judiciary Committee. I think this was after she was appointed to the Supreme Court, but was making this, or no, it was Justice Barrett as she was being nominated. That's who said it. As she was being nominated, she made this comment talking about the difference between individual rights and civic rights.
Right.
And I think she was quoting Kagan or someone like that, but she said, in the case law, there's these two different kinds of rights: individual rights, which are for individual persons and individual benefits, such as the right of freedom of speech, and this separate category, which is civic rights. And the other example, including voting, is the right to serve on a jury.
Right.
So there's no like individual right to serve on a jury. It's sort of this collective right for the collective benefit.
Yeah, you can't walk up and serve on a jury, for example. Yeah. Like you can't just go exercise that right. You have to be given opportunity to exercise that right by the state.
And I have actually seen a couple cases. It's not that often, but it has happened once or twice where a person has been denied sitting on a jury, is actually sued, saying, I had a right to serve on this jury. Not only did I not want to be exempted, I demand to sit on this jury. And those cases don't go anywhere either.
Some of them, a couple of them did. I don't remember the citations, but it was of course around the idea of being denied the right to sit on a jury because of your race. Sure. And stuff like that. And those are the only real cases. And again, this idea of it goes to the idea that you can stop someone from doing something for any reason. Like you can fire someone for any reason in a right to work state. It's like, well, you can't actually fire someone for any reason. there are some things that we can't do.
There are protected reasons.
Right. And so it's the same thing with your civic rights. Like once you're bestowed civic rights, you can't be denied them based on a protected status. Sure. But if you haven't been bestowed those civic rights, then you don't really have a right to do them. Like if they took away general elections tomorrow, you'd have no, well, I mean, the Supreme Court may intervene, but there'd be no presumptive right to walk up and say, I demand to vote. And you go, well, go somewhere else. go to a district that allows it, I guess. Yeah. But yeah, so I've always kind of mulled the idea of California, if they really wanted to, if they really had a split with the federal government over sanctuary cities and the immigration issue, if they chose their electors by popular election of undocumented citizens or undocumented people.
That'd be good. So they really go for broke.
Yeah, the only people who can vote are illegal aliens. That's how we're really gonna do it. That would
that'll make the originalists cringe a little bit. Yeah.
Wouldn't that be a fun dilemma for them to deal with, though? I mean, like, I almost want them to do it just for the meme of it.
Oh yeah. Yeah, no, I think unfortunately that would be legal on any other grounds they want to. I mean, the only thing I could think that might not be legal is something that would be truly arbitrary, because you could make this idea that the government has to act with some minimal rationale
Right.
for any exercise of power. So maybe if they did it on something truly arbitrary, like we're going to do it on just a coin toss with nothing more,
Right.
maybe that wouldn't fly, but I'd still have to think about it for a second.
It's a weird question, and it's one of the things, and this is one of the things you brought up as a potential topic today that I think will transition into this at some point, like a 4-month-old. But it's the idea of court packing, and our preconceptions about government. And I've been talking about this generally for the past 1.5 to 2 years, especially in regards to comments about Trump's use of power or lack of use of power, is that we really exist in our government. We have checks and balances, sure, but we exist largely on this idea of just sort of a gentleman's agreement that we're going to do things in this way. Like, the president isn't going to just appoint justices to the court, not because there's a law that says he can't in the Judiciary Act, because the real question would be if you had for example, a Democrat House and a Republican Senate and a Republican president, and the Judiciary Act says, well, you can only appoint 9 justices, but the Constitution says that the president can appoint justice or nominate a justice and the Senate can approve it and the House has no say. So the Judiciary Act's restriction on the nomination and approval of a justice may be an unconstitutional use of power, because Congress doesn't have any right to, or the House doesn't have any binding right or power to restrict the Senate or the president in that act. So we have 9 justices because no one has decided to do that. But we really could see something like that happen. Of course, if it goes the way many people are kind of surmising this will happen, would be Biden gets elected, the Democrats take the Senate, and the Democrats maintain the House. So presumably they could just modify the Judiciary Act to add as many seats as they wanted if they had enough clout to do it.
That's what I think is probably most likely to happen. They'll write a Judiciary Act that says that we're raising the number to 11, and as soon as 2 more appointments are made, the number is automatically reduced back to 9. So that so it would be capped. It would be capped at 9, but they put 2 people on.
So you think they'll
additional seats?
So they'll pack it to basically 11 justices and overdo. Well, it'd still be 6-5, wouldn't it? At that point, Republican versus Democrat appointees. Although Roberts doesn't always side with Republicans, obviously. But So you don't think they do 13 or something like that?
I don't know. Maybe they will. I mean, but I think whatever they do, that they'll probably just then change it back to 9 or something, so that that the Republicans will be denied a seat, until they can get control of the House, Senate, and presidency. Which, if they're able to admit DC as a state and or Puerto Rico as a state, which will be presumably much harder for the Republicans to gain enough votes in the Senate, which I think is part of the point.
Oh, if DC becomes a state, the Republicans lose the Senate real fast. Well, I mean, they lose 2 seats.
If DC becomes a state and Puerto Rico becomes a state, that's 4 additional Senate seats, which are presumably Democratic. And so then so it's like a perpetual. They can keep the Senate indefinitely.
DC might be Republican. It's plus 80 for Biden. It doesn't matter what you think about the polls. Washington DC is 80 points ahead for Biden. Didn't
it go for something like 92 or 93% for Hillary Clinton?
It's something like that. The polling data is 80 plus 80 for Biden. So yeah, that would be somewhere in the neighborhood of 90-10. So yeah, that would be a terrible plan. DC should never be a state. Their senators should always be useless. And Puerto Rico, I don't really care. Like, just neutrally if they become a state. But if they become a state for the power grab, it's pretty bogus. But
now, I do have one question on DC becoming a state, because there is this one potential constitutional problem. Was it the 22nd Amendment, which gives electoral votes to DC, gives 3 electoral votes to DC?
let's
Or
see.
to the federal district? It's something like that.
I'm looking to the 20. Now you're getting really deep in there. 22nd Amendment.
Something like that.
That's not DC. That's the terms of the president. Okay, here it's 23rd.
23rd.
How could you get this so wrong? Oh my God.
Off by 1.
The
So this is my question, or the potential constitutional problem with DC becoming a state. So 23rd Amendment says the district constituting the seat of government in the United States shall appoint in such matters Congress may direct a number of electors equal to if it were a state. So they get 3 votes in the electoral college. So they get to vote for president.
Yep.
But the problem is, if you make DC a state, then you've essentially created an unamended this provision, because it presumes in section 1 the district constituting the seat of government. So if you make it a state, it's no longer a district. But section 1 says there is a district.
Yeah.
So how can you? So there's this problem, because if you make DC a state, then the 23rd Amendment essentially becomes repealed by implication, which seems really odd for a constitutional amendment.
Yeah, that whoever passed the 23rd Amendment just shouldn't. That 1961 it was ratified.
Yeah.
Probably shouldn't have been done, in my opinion. I don't see why DC gets a vote. Just count it as Maryland, and move on. But that's me. I'm cynical.
Yeah, I know. Why not make DC Maryland again? They made half of DC Virginia again, so that would solve that problem too.
Yeah. There you go.
DC used to include Alexandria County, which is now Arlington.
Sure.
But so I mean, it used to extend quite a bit into Virginia.
Yeah, and I don't understand why the federal district gets 3 electoral votes. Like, to me, that just doesn't make any sense. It should be rolled into the state. Just because there's a carved out district doesn't mean that they should get 3 more votes. Effectively, it gives Maryland a disproportionate amount of electoral votes for its population in a weird way. But anyway, so we've got SCOTUS stuff to talk about, and then and then also the thing I didn't put in here is potentially discussing Billy Mitchell's ongoing lawsuit.
Yes, I did read it and got myself briefed on it. So
yeah,
good times.
So we can we'll kind of move through topics as we go. Very free form as always. What are you drinking tonight?
Today is Gentleman Jack.
Oh,
it's
nice.
One of my personal favorites. Yeah, I really like that more mellowed flavor. It's one of my classic favorites.
I don't like Jack on its own, but the Gentleman Jack is good, I will say.
Yeah, I don't like regular Jack. I do like the Gentleman Jack though.
A man of culture and distinction. I'm gonna drink what my barber tells me all the Mexicans drink, which is Buchanan's Deluxe. He is a Mexican gentleman, so it's not racist for him to say it. This is actually it's a pretty cheap blended Scotch, but it's actually pretty good. I'd recommend it for a nice, very inexpensive drink. It's got a weird ball cap, like a ball gag cap, like I kidnapped it or something. Weird. Anyway, so let me read a couple of these early chats, and then we'll get into the Floyd discussion and kind of talk about that a little bit. So Ryan Mercado says, when are you going to introduce Uncivil Law to the Big Brain panel? Oh, I think that's a good idea for a show, since there are a lot of good topics that could be discussed with him and the panel together. Well, I don't know. I'll have to think about it. The Big Brain panel is, of course, just a panel of lawyers, and we all get drunk and tell stories and make fun of stuff. So it's like it's like every other show I do, but with more lawyers in it. Bad Vibe says, I'm calling shenanigans on Carlson document loss. Fax the copies, don't mail the originals. Something smells fishy here. I don't know what that is. What is the Carlson document loss? Are you familiar with this news story?
I am not.
Okay. Puggernaut says they never caught the Zodiac killer. Oh yeah, we got to talk about Section 230 a little bit too, probably.
Sure.
So they never caught
we talked about because Facebook and Twitter were on Capitol Hill lying today. That was fun.
That was great. You know what? I learned, or I reaffirmed today that I would not want to be a witness that Ted Cruz is cross-examining, because he was pretty brutal to Jack. It was good. Jack looked like a complete moron to me. I don't know. He always does, though.
I was about to say, as opposed to what? You know? That's what I was about to say.
When does Jack not look like a homeless idiot? So Puggernaut says they never caught the Zodiac killer, but there he was, just on C-SPAN, cutting up Jack Dorsey like a Christmas ham.
Nice.
Twitter doesn't influence elections, but protects the integrity of the conversations around elections. The fuck? Yeah, that was brilliant. And I love that he's like, no, New York Post isn't banned. They just have to go in and delete their post, and then they can be unbanned. It's like, well, that's kind of the whole problem.
It's like I need you to stop right there. I need you to think about what you just said and try to say it again, because I don't think you fully thought that through.
Yeah, but no, he's like, no, that's all they need to do. It's like, wait, you can't just go in and flip the switch that says blocked? Like, somewhere there's got to be a switch on Twitter that just says unblock, that they can do it. Because presumably you have to be able to do that, because that's the whole point of the appeals process. Oh, that's interesting.
Yeah, I saw because their admin panel got leaked one time, seeing behind the scenes, and like there's there's blacklists and stuff. So yeah, I think you can go in there and do it.
But here's
the CEO of Twitter, figure it out.
Here's an interesting proposition. I want to know what you think about this. Twitter represents to all of its customers that there's an appeal process for a wrongly determined suspension. Has no one ever successfully appealed?
I don't know. And more to my interest, I'm wondering if there's an FTC issue in there, because whether or not they are the speaker for the purposes of 230, they still have to have honest business practices.
Right.
So I think there'd be an FTC issue there because they're misrepresenting their product.
Right. Because for those of you who haven't been suspended off of Twitter, let me lend my experience to you. When you get a suspension, be it a 12-day, if it's just a 12-hour or 7-day or whatever suspension, that you may get a temporary suspension rather than a permanent suspension. You have a list of offending posts, and you have the opportunity to either appeal the decision for the suspension, or you can delete the offending posts, and then your timer starts to run at that point. So if you get a 12-hour suspension, you check your phone an hour later, you find out that you've been suspended from Twitter for an hour. You go in, you delete the offending post, your 12 hours starts at that moment, and then you go on. Dorsey today represented on Capitol Hill that the New York Post must remove their tweet to be able to be unbanned. And then I believe he said they could repost it at that time and it would be fine. But he said they must remove it first, which, if that's true, then that means that the representation that there is an appeal process which would involve not removing your offending tweet would be a lie. And that would be caught up in one of those great catch-all clauses called deceptive business practices under the FTC or under individual state law. California has very strong deceptive business practice legislation. So does New York, I think. But I don't know, because they have all of the banks. So maybe not in New York. I don't. But anyway, and those basically, like, how you prevail on deceptive business practices, just to show that their business practice was not in line with the normal idea of doing business. So dishonesty, just basic dishonesty, is a deceptive business practice.
Yeah.
So very interesting. I wonder, that would be great if Jack got sued by the New York Post for that. I don't think they will. A Bad Vibe says, "Don't go AWOL, Nikki. We can't replace you easily." I won't. Weirdo with a cello says, "Say hello to my little friend." Hi, buddy. Where's my fucking money? Okay. Very weird. Swarm069 says, Toddler trans rights, and you guys are serious. I hope there's an asteroid coming this way, and I hope it's coming soon. Adam D says, thank you, Nick, for covering our case last night. We had a total victory in court this morning. This is up in Michigan. And in Michigan, in Detroit specifically, they were instructing their ballot takers. They're instructing their ballot takers to utilize social distancing requirements to keep the poll challengers 6 feet away from the ballot table, where they would be where they would be unable to witness what was actually going on.
I love it.
They went to court on it on an emergency hearing this morning and apparently won, so they will no longer be allowed to do that. Yeah, the state conceded and poll challengers will work unimpeded. Thank you, too, for ongoing coverage of Lucas Gerhardt's case. We will prevail. Are you familiar with Lucas Gerhardt?
I'm not.
Okay, I'll give you a brief summary because I like to tell this one to piss people off. Lucas is he's 21 or 22 now. I think he was 20 when he got arrested. He was going to college in the Upper Peninsula of Michigan, and he sent to his Snapchat friends.
Oh, yeah, the picture with the gun? Yeah,
yes.
That guy?
Yeah.
Okay, yeah, I know the story. Yeah.
Right. He's still incarcerated.
Yeah, that's pretty messed up.
Now they have his new lawyers. He's on like his fourth lawyer. But his new lawyers have sued the prosecutor for charging him under the statute when the statute explicitly says that this statute cannot be used to impede someone's right to free speech. And so they've brought a civil action against the prosecutor separate from the criminal action.
It's slightly hard for me to get my mind around what went wrong originally for this party to get started, because it doesn't make any sense. And what went wrong at the early stage of this so that it got started is the thing that sort of perplexes me. Because I sort of understand once things get started, there's a momentum and sunk costs and all that kind of stuff and ego protection that would prevent you from doing things. But how did it ever get started?
Part of that is what you just said from what I understand. The long and short is one of the early attorneys. I don't know if he was the first or second attorney, but he's a young guy and he's kind of a big shot and he's trying to make a social media presence while being an attorney. I don't know, maybe like a Lynn Wood or something like that. Because he's not like me where he wants to do social media more than the legal work. He wants to use the social media to boost his legal work, I guess. Sort of like I said, like a Lynn Wood. So the night before the habeas corpus hearing, to have Lucas released from his house arrest shackle, he went on Facebook and did a live video laying out his argument about how he was going to destroy the prosecutor in the case. And the prosecutor watched it. And so when they went into court the next day, the prosecutor knew all of the arguments that were coming out and also was really pissed off because this guy was talking about how they were going to just destroy the prosecutor and it wasn't even going to be funny. And then he was going to broadcast the hearing, he said, except he didn't have leave of the court to do it. So when he first shows up, he's trying to set up a camera and ask the judge to allow him to record. And the judge is like, no, you can't do that. And so he pissed off the judge right at the start. It was just an absolute mess. And that guy may have done a large amount of damage to Lucas's case at the onset. And that seems to be one of the lingering problems. But the other problem, and get this. So while they're at this hearing to determine if he can be released from his ankle bracelet, the prosecutor starts playing footage of the Christchurch shooting from New Zealand.
Okay, that seems irrelevant and prejudicial.
And his lawyer didn't object to it.
That seems problematic.
I'd be jump kicking the damn screen. Objection.
So his lawyer's like, I see no problem with this. That's a bold strategy, Cotton. Not exactly sure what you're going for there. Seems like it might be a bit prejudicial. Seems like it might be a little inflammatory.
So the judge,
Irrelevance.
yeah, the judge
watches
watches.
none of these things. Okay, that's fine.
Judge watches a Kiwi just flat out murder like 50 people, right, at a mosque, and then he's like, "No, he can't get out." Like immediately. Wait a minute. That's not the standard for why someone shouldn't be released. That someone in New Zealand decided to shoot up a mosque has nothing to do with a kid bringing a gun legally in Michigan and checking it in.
Why don't we just do the Matrix scene when they enter the building and shoot up the guards on the entryway to get to to Morpheus on the upper floor where there's that.
It was an Aussie. Sorry. Yeah.
Just do that scene from the Matrix. Be like, if you let him go, this is what will happen. Walls of guns just come by without these guns.
Yeah. Sorry.
This is the minigun he will use.
I did not mean to besmirch the free communist state of New Zealand. It was definitely an Aussie who did it. Sorry. Let's see. Adam says Nick Somberg, that's the attorney we're talking about, was horrible, but he didn't even get hired until months into the case. Things went haywire with Lucas being charged in the first place. And I agree, but it seems like had things been handled early on appropriately, that could have been taken care of. But yeah, I mean, it's a mess of a case, and the poor kid's been, I can't imagine being 21 years old and losing a year of your life. He's had to just be at home. He can't work, can't go to school.
Well, in all fairness, for the last year,
I mean, kind of. So, but if I want to go to Walmart, I just put on a mask and it's annoying. That's it.
Yeah.
I can still go. He can't leave.
Yeah.
But yeah, it's anyway. Okay. But yeah, congratulations, Adam, on the victory there, and I hope things do go well for Lucas. R.W. Bimby says, Fed laws against pot and secession. Texas can legalize pot and secession, then legally secede. That's how legalized works, right? States allow themselves to violate federal laws. Right, yeah, Texas secession is kind of, it's quite possibly a legal myth. But it's a very popular one.
Myth. The one that's more interesting is the clause that apparently lets them break themselves up into 5 states, and whether or not that is legal or not, because you need consent of Congress. And then you could say, well, did they basically get proactive consent in the first place? I don't know. They ever try to be an interesting legal issue, but
counter argument
because we're about to add in Puerto Rico and DC, and we need a couple more states to balance it out. Now would be a good time to find out, I guess.
Counter argument. The original Texas territory has already been broken up into 5 states.
Sure.
Oklahoma, Colorado,
that's fair.
Montana, Wyoming, I think. I don't know if those are the right states, but yeah, basically like a line going up, it already has. So I think that would be an argument against that proposition as well. I think the Treaty of the Guadalupe or whatever is probably already done. Run its course. But yeah, it was Texas v. White or whatever, right? Was the post-Civil War case where they basically said, no, you didn't have the right to secede because you lost. Which is how it goes. But yeah, that's and I think that was R.W. Bimby's point is, yeah, you can't just decide to violate federal law as a state. You can, as long as the feds don't want to enforce it. Viden the Cold One says, this screen name I chose some 15 years ago has caused me confusion because when I hear Biden, I think people are saying Viden. Also, shill for likes and subs so you can get your play button, you boomer, enjoying your guest. Yeah, if you're not subscribed, do it now, immediately. Actually, if you are subscribed, check, because you would not believe the rate at which you guys get purged off of my subscription rolls every time I do a live stream. So it happens. It happens. And if you haven't liked the stream, like the stream. Maybe I'll do a funny shot or something and wake up vomiting. And one more, and then we can talk about Floyd here. Kyle133 said, wife and I just got back home with our new baby girl. Hey, congrats, man. Thank God there's no issues for our first. Too tired to watch the stream tonight. It's not changing forever. Here's some money for the great entertainment you'll provide me later. God bless you all and have a great night. Hey, man, congrats. Get some rest. You'll need it. Your life's about to be a fun kind of hell for the next, like years. But it'll be good. It'll be worth it in the end. Okay. So let's talk George Floyd.
Yeah, sure.
So the other day, as both you and I have covered, the judge in George Floyd's case has dropped the third-degree murder charge against Derek Chauvin. Now, my initial assessment of the case was that I thought the third-degree murder charge was the only murder charge they'd be able to get to stick.
Mm-hmm.
I have little faith in their ability to convict on second. And I haven't really changed that position. I think I may have moved closer to them being able to stick second, but I'm still in the big X to doubt category. But I was watching you go through the filing, and props and kudos to you for doing it. That's a monstrous opinion. 107 pages because it covers all four officers.
Yep.
So kudos for actually going through it, and I do recommend people go check it out. But I was watching the part about the third degree being dropped and the second degree being in there, and you seem to have a little more confidence in their ability to convict on second degree. So I figured we should discuss that a little bit.
Yeah, it's interesting because when you're reading your analysis, it's interesting because we all agree on the elements, and we're just kind of disagreeing the degree to which we think the facts are there to support the legal conclusions.
Right.
So that's really interesting. But there's a couple things that people seem to be getting wrong on this generally, as far as I can tell from my chat, and perhaps this is true of your chat too. So the second degree murder that we're here on is a variant of felony murder.
Right.
So we don't need the intent to kill. So some people were like, well, Chauvin wasn't trying to kill him. He didn't have the intent to kill. But we don't need that because we are on here on felony murder. We don't need the underlying desire or intent to kill. What we need is the intent to commit the underlying felony, which is the felony assault, and that a death resulted from that action.
Exactly.
So that's the first thing that people seem to not fully appreciate. The second thing that I think that they're getting wrong is on the fentanyl or drug use and things like that.
Yes.
Because
very
whether or not
common.
Floyd was on fentanyl or like literally anything else or not, or because of prior drug use or for really any reason had some sort of compromised health system, it doesn't matter. It's because there's this classic idea: you take the victim as you find them.
Right.
So if you do this intentional thing and it wouldn't normally hurt someone, but it hurts someone more because of some flaw of their person, whether it's self-inflicted or otherwise, then sucks to be you. You take the victim as you find them, and if it causes more damage, it causes more damage. So
it's the fragile skull or the glass skull theory.
Eggshell skull.
Yeah.
Eggshell skull. Yeah. So it's like, in order for the people who are like, well, he was on fentanyl, for them to be right, he would have had to die exactly when he did, regardless of what the police did. If the police accelerated his death at all, in any degree, they have a problem.
Right.
And so I think people are missing this because they're like, well, he would have died later. He was in the process of having a heart attack. He was already saying he couldn't breathe before they ever put knees on him, and so forth and so on. I'm like, okay, fine. If all that's true and he was on his way to a heart attack, great. But if the police accelerated that, that's murder, So
Yeah.
I think people are really missing that. And so then the real challenge seems to be the intent to commit the underlying felony. That's where this is really coming down to for me.
Right.
And to get there, that there's these two elements the way I see the statute. You have to have the intentional desire to inflict harm or the intentional desire to cause Floyd to fear death or grievous harm. And that harm did in fact occur. So the harm did in fact occur. We are there.
Yep, we've got that.
The only thing that you're looking for is that intentional infliction to inflict harm. Did he have the intent to do it? And your ideas of justification are very good. That he has some ideas that he was justified at some point for some of his actions, but the state's counter just seems too good. It went on for so long, and 4 minutes past the point of him stopping breathing, and he was getting all these warnings from people, and he had this just complete, it's like, how could he not know? So, you can infer intent from the act, and it's like, how can you, I think you're there. So I think their odds at second degree are looking pretty good to my eye.
Yeah, and I agree with what you've said. I think that Chauvin will get a, and I know this is hard to think about with a jury, but I think he and other expert testimony wearing their uniforms in court will have a very strong ability to argue that what he did was a standard practice hold, even though I know he violates very clearly the regulations around the hold. But what they will testify is that, despite the best training, police officers can make a good faith effort and still violate those rules. And sometimes that will result in harm, even if it's not intentional. And I think that's where they're going to go, in the idea that, and I agree, by the way. And I think someone reminded me, I had a brilliant line. I've got to toot my own horn on this. In some video, I said, George Floyd killed himself and Derek Chauvin framed himself. And it was this idea that the hard part for Chauvin is he's going to be kneeling on top of this guy looking like a smug asshole.
Yeah.
But I think that they will, if they can successfully argue that he's justified in getting on top of him in the first place, I think they'll get some deference on the idea that he should have gotten off of him sooner, by saying that when you're in the moment, you've got people yelling at you, you've got adrenaline going, and your sense of time isn't so simple as to say, well, what's 30 seconds and what's 2 minutes, what's 4 minutes when you're ramped up, and how do you know the person hasn't stopped? And they're going to have use of force experts come in and testify on behalf of Chauvin, if they have any brains, that will say that in these types of situations, your ability to understand the flow of time is skewed, and your ability to act can be impaired through no ill intent of your own. And that, I think, is how you get to the argument where they're, and I think this is them arguing in the alternative, to be clear, that he's only guilty of manslaughter rather than murder.
Sure.
And
I don't remember who I heard it from, but I heard someone say, like, in the very early days after it, that what they saw in Chauvin's eyes was this this desire to project and be in control. There was this defiance to him, like, the crowd was telling him to stop, and the way the person analyzed it, and I thought was pretty good, was saying he was trying to show the crowd, almost specifically because they were challenging him. No, I'm in control. I'm in control. It's this sort of egoistic, macho kind of thing of just asserting control for its own sake. So he's not yielding merely to show that, he's in power. And if that's what's going through his mind, is that basically like, it's my intent to, I'm intending to do this to show my control. So, I mean, you're having to read a lot of things into it. I think your analysis is right on the money of some of the defenses that they're going to do. They're going to bring in the experts to show, like, this is standard practice and standard procedure, show the training, show, like, how it's not a big deal, and so forth and so on. I think that the counters are better. So, I'm giving, at this point, I'm giving odds to convict under second degree. If I had to peg it right now, I'd say about 70% is where I'm pegging it to convict on second degree. And because I just think the tape is so damning, and they'll bring in people from the crowd. They'll bring in the witnesses who are yelling. They'll bring in the volunteer firefighter who was trying to get to him and denied. They'll bring the girl who took the cell phone video and the things that were screaming, and just talking about his cold, dead stare of defiant will. And I don't think it's going very well. So yeah, I think the second degree murder is a lot more promising than you do.
Yeah, and the cool thing about that is that's fine. It's as long as we agree on the elements and the defenses. I hate the idea that the blue privilege in court.
Mm-mm.
I hate it.
Mhm.
I've come up against it a couple times, and it's just like, you just lied on the stand.
Mhm.
I know you lied on the stand. I just can't prove you did. And so I think that deferential treatment that cops will get, less so Chauvin and more, I think the experts that they bring in
Yeah.
is where I think they're going to get a big boost. But it's going to depend heavily on the jury. But here's the
Mhm.
thing,
Mhm.
the prosecution is likely going to try and strike anyone who's black from that jury. Or wait, no, the prosecution wants only black people on the jury.
Yeah, strike all the white
Right.
people.
But the defense is going to make a very compelling reason why all the black people are disqualifiable. It's gonna be tough, but they have to. They have to
Bats
try
and
that.
challenges for days, baby.
Yeah, they're gonna. That's gonna be sort of the strategy, and it's really gonna depend, I think, on what kind of jury pool they get. And I think the other thing, if Chauvin's lawyers haven't done this, I'm surprised. Maybe they have. I don't know. Have they moved to remove it to a different jurisdiction?
Not to the best of my knowledge, no, but I would imagine that has to be coming.
I think they're gonna. I think what they're gonna. Maybe what they'll do is they'll get to jury selection, and they'll start pooling jurors. They'll put out a questionnaire, and all of so many of the questionnaires are going to come back that they know about the case, that they know that they don't like this guy, or they don't like the riots, or they know someone who was hurt or whatever, that they're going to disqualify so many jurors that they'll then use that, or the potential disqualification of jurors as basis to move it. Maybe that'd be, if they haven't done it yet, that's the only thing I can imagine they're waiting for, unless they think they can win in Hennepin County. I would move it to outstate Minnesota if they can.
I don't think you can do that. I don't think you can move it out of state. Can you do that?
Not out of state, just to out of the Twin Cities.
Yeah, that you can do.
Yeah. So if they can,
unless there's some new twist of Minnesota law that somehow allows you to have trials out of the state, that'd be a whole new world.
if they can do that, I think his chances go up dramatically. And of course the one argument that I think they're really going to hammer on, which I don't think it's a great argument unless they've got some masterful toxicologists lined up, is they're going to try and make the argument that he was on his way to death before Chauvin intervened. If
I think trying to go down the fentanyl path is just a mistake. I can't imagine that being a fruitful line for the defense, and credibility before the jury is so important, as I'm sure you can appreciate. And if you go with this really half-baked thing, so I mean, I'm not in the defense lawyer's head, nor do I have the familiarity, but I would probably not be going down that fentanyl line. I just can't imagine that being productive.
I don't think it is either. But I'm wondering what kind of experts they're going to bring in, because one thing they have to do is they have to counter the Hennepin County Medical Examiner's report with a better expert. And one way to maybe do that is to bring in an expert who will agree with the toxicology aspects of it, focus on that, and then try and discredit his ruling of complications from the knee, which is going to be very tough to do, I think. But that's the only way I can see them reasonably trying to defend the case. Beyond,
they're better off with the underlying intent to cause harm element rather than the being a causal factor, I think. I mean, again, I've not tried criminal cases. I've certainly not tried these kinds of criminal cases. So what?
Me either.
But my gut says I wouldn't be going down that line. I'd be trying to look for the intent element and trying to go there rather than the causal factor.
My minor disagreement with that is that if they eliminate the intent, we go to manslaughter too. And that's if they say, yeah, he did all these things, no intent, then they're going to have a hard time I mean, those are the elements of manslaughter too. Is basically murder 2 minus the intent. I think, and I think that's going to be.
The only thing that saves you there is you have to show the subjective intent to consciously disregard a perceived harm to get the manslaughter. So you do have that. It's not quite intent, but you do have that subjective element to disregard.
I think
you have to prove.
All I would do as the prosecution just have that smug, that look on his face.
I'm not saying it would be easy.
Yeah.
It's a tough road to hoe, man. So yeah, I think his fellow officers are much better off. I think their intent element is a lot better. To be aiding and abetting, you have to show the intent to assist a crime is occurring.
Yeah,
I think that knowledge requirement is going to be tricky for the state.
I think all 3 of the other officers walk. I cannot.
Yeah, I think that's likely.
I was surprised they charged them, in all honesty, especially when body cam footage had the one guy checking the pulse, suggesting that they roll over, roll him onto his side. I'm like, how are you going to charge this guy with aiding and abetting when he's actively suggesting ways to prevent the death?
Yeah, really.
So that's what I want to know. What's in the prosecutors' heads on that one? I think they should have let them. I honestly think they should have let them walk. I just don't see any criminal act that they did. I mean, maybe you do some discipline to them in the police force, fire them, whatever. But I, outside of maybe the Asian guy who was doing crowd control, the other 2 guys, I mean, they were just restraining the guy properly. But I mean, the guy doing crowd control, I don't know what he was supposed to do either, but he had more seniority than the other 2. So I think maybe you could say he should have done something, but I still don't know.
They're basically trying to say he's the lookout. The state's theory he's the lookout for the bank robbery.
Yeah, I mean, look out for who's coming.
Give me a break, man. Jeez, Lord. You really think that he's like, I'm gonna watch for anyone in the crowd? It's like he really had the intent to be this lookout. I'm doubtful.
No,
the crowd guys, like, how can he? Because his focus is split between the crowd and something, so his knowledge element's even harder to prove. There's the one guy who's 4 days in the field. He'd been an officer longer than that, but it's his 4th day on the field. And apparently the state thinks he's supposed to tackle the 20-year veteran.
Yeah, not a chance.
Okay. That doesn't seem like it's going to happen.
No,
and
it's
one other guy is like, no. So I think Chauvin Chauvin's going to take the fall. And I think these other ones, their right probably is to walk. I'm surprised that they're charged, to be honest.
Yeah, I don't think so either. We've got a comment in the chat from a guy named Coppercab, who welcome to the show. He's a YouTuber, but I'm not familiar with his content. But this is interesting. Says, hopefully these 2 white men are smart enough to recognize that toddlers should not be assigned genders and should be given the choice to decide for themselves. I guess it's about our second topic, which we're going to get to.
Yeah.
But there's one chat from this topic, and I think we can maybe move on. Bad Vibe says, so if it can be shown that Chauvin continued beyond Floyd's active struggle and crowd statements, could that be argued as evidence of intent? Yeah, that's how you're going to go about it. And that's one of the things I said is a big problem for Chauvin in general, is that he had the opportunity to let go of the neck restraint many, many times and just chose not to. Even after the EMTs arrived, he remained on him for another minute.
That was good for a good minute solid after the EMTs arrived. Yeah, that's just genius.
Right. But it goes to one of the things that's brought up in the paperwork, and it's one of the things I've mentioned several times when people bring up the idea that, well, they train you on the knee restraint. They do, or a leg restraint to the neck, right? They do train you on the use of leg restraints to the neck, and it's clearly stated in the manual that they are not to be applied for more than about 30 seconds. And they're not to be applied unless there's an active struggle, and if the person becomes non-responsive, they are to immediately administer CPR and cease the restraint. And so That's the training. So if you're going to argue that he was like super well trained and he was just following his training, you're going to run into really big problems, especially on cross-exam, when you start getting into, well, why didn't you stop as you're trained to do? If you're talking about being a 20-year veteran who's expertly trained in this restraint technique, but you're not following the training that you're given. And that provides a big sort of credibility problem for him. Of course, I don't think he's going to testify on his own behalf, but they're going to, if they've got an expert in there on the use of force testifying about how police are to administer this restraint on cross, they're going to bring up, and when do they let it go? And when do they let it go? That's going to be the entire line of questioning. And so you're saying that a trained officer would know to let it go if the person stopped moving, for example. So what you're telling us that if someone did stop moving and the officer was informed that they stopped moving and maybe were non-responsive or a pulse couldn't be found, that the officer should immediately remove his knee and then start administering CPR. That's what you're telling us. And that's how the cross-exam is going to go on that section for whatever expert ends up testifying. Because like I said, I don't think Chauvin is, maybe he testifies, but I think that's a really tough call. I don't know if you want to put that guy in the stand because he might be really unlikable. So we'll see. But for Copper Cab's benefit, should we move on to the toddler trans rights?
Oh yeah,
section?
No, because it's a horror show.
Yes. Okay. So let's do a little bit of background on this. So I'll try here. So this couple is older, elderly couple. They have a grandchild. Of course, well, they have a grandchild who gives birth to a great-grandchild. The great-grandchild is removed from the grandchild's custody for some unrelated reason. Do we have any idea why? Drugs or something?
It's not specified.
Okay. So the great-grandchild is removed. Now, in the foster system in most states, what they will attempt to do, if possible, is place a child with family, if that's a thing that they can do. If there is no family who is competent or willing, then they go into regular sort of foster care. In this case, you have the great-grandparents saying, we'll take the kid. And then they were deemed not worthy, right? Like Bill and Ted, not worthy. Or Wayne and Garth, not Bill and Ted. Wayne and Garth, not worthy. So can you talk about that?
Yeah, so this great-grandchild was born September 2019, removed from their mother. So in January, which is 4 months later, January of 2020, the great-grandparents apply for a foster care license to foster care their own great-grandchild. And the Department of Child Services over here wants to ask some questions to see whether or not these great-grandparents are fit. And you gotta love these questions over here. So I'll just read them again. These questions included these following specific examples, which are quoted by the court. How would we react if HV, which is the 4-month-old, how would we react if HV was a lesbian? Would we allow HV to have a girl spend the night at our home as HV's romantic partner?
Yeah, and so an important thing to remember here is that this is a 4-month-old.
4-month-old
who has not, who according to the court record, as far as I know, has not expressed a gender identity at all at this point. So what they're doing is they're asking a hypothetical question on how people would react should this child hypothetically develop a different expressing gender identity or a different sexual orientation. It hasn't actually happened yet. The mother hasn't alleged it. It just it's just
these appear to just be standard questions, apparently.
Right.
Or I guess I suppose there's more.
Yeah.
If at 15 years old, HV, the 4-month-old, wanted to undergo hormone therapy to change her sexual appearance. Would we support that decision and transport her for those treatments? If, as a teenager, HV, the 4-month-old, wanted to dress like a boy and be called by a boy's name, would we accept her decision and allow her to act in that manner?
How can you answer that question
Great.
15 years out?
I don't know.
Like,
don't know.
Because okay, so let's do it this way. So let's say these are hardcore conservative Christians or whatever, and they don't believe in gender identity in any way, and they certainly don't believe in hormone replacement therapy or anything like that. Right now, they'll say no. But of course, the baby hasn't expressed anything. They haven't developed a relationship with this person beyond just the fact that it is their biological offspring. A lot of people in that situation do change their minds. Like, there's 15 years of time for if this weird circumstance could manifest, that they could decide differently about how they feel about something. That happens to people quite a bit, you know. Many of my kids who are gay, they'll be in the ground or whatever, and then it happens, and they're like, "Well, but I like you, you know. I love you. You're my kid, and I've developed this relationship with you over decades, and so now I may not like it, but I'll support it." Like that happens.
Yeah, and then in getting into the next Orwellian stage of this thing, where we get into the re-education camp portion of the evening. So after this child services person asked these questions and got the wrong answers, the court says, after apprising his supervisor, they descended to send the great-grandparents educational materials about LGBTQ children. The email that included these materials invited them to review the materials so that they could, quote, make a more informed decision about supporting LGBTQ youth in foster care, unquote. The re-education is real, my friends. The re-education is real.
Yeah, and it's that's a crazy aspect of it, because they basically this is where we get into legal issues that you brought up a little bit after this section about basically applying a religious test to foster care. Mm-hmm. And this is a real constitutional problem, but by providing them with the educational materials, the state has indicated that there is one correct way to answer this set of questions, and they presumably answered it wrong, and now are benevolently given an opportunity to correct their mistake.
There is, in fact, the one true faith. It may be a secular faith, but there is the one true faith. And if you don't respond with the answers of the one true faith from the priesthood, you will be punished for your sins. Yeah. So yeah, it continues to get worse. Somehow, amazingly, it continues to get worse. So after these materials were sent, they asked them how they felt, and they said they still had a steadfast conviction that they wouldn't support the hormone treatment. So the re-education didn't work, but the government wanted to make sure. So they had some new questions for the great-grandparents, new revised questions, which included the following. If HV, the 4-month-old, had a lesbian girlfriend, would we be willing to have her visit our home and possibly travel with us?
At what age? That one's just an ageless question.
It is unspecified in this question what the age of this proverbial. Well, it's unspecified the age of HV or her lesbian girlfriend is in this hypothetical.
Right, because the lesbian girlfriend could be like Zoe Quinn or something. That was a joke. That was a joke.
If at age 14, a doctor ordered HV, the 4-month-old, to undergo hormone therapy to change her sexual appearance, would we comply with that order? Would we comply with that order as like a doctor can actually compel you? Like it's an order from an authority you have to follow. Would you comply with the order from the doctor who ordered this hormone therapy?
And now, so what you brought up in your video about this, the doctors don't do that. Doctors don't order treatment. They recommend treatment plans, and then
Yeah.
you have at least an illusion of autonomy in your healthcare. It's kind of one of our basic held rights. It's one right that is so universally held that during the Obamacare debate, both parties were advocating for healthcare autonomy in the thing. It's like, whoa, this is just about how we're paying for your healthcare. Remember, if you like your doctor, you can keep it. We certainly don't want to get in between a patient and their doctor. We're just talking about how you pay for it. And that's, both parties agree that autonomy in healthcare is important. But I am noticing a little bit of a trend here where, particularly with minors and with doctors, and in this particular field of a gender identity, we're starting to see where a doctor is being given, well, not just this one. There was, of course, the case of Justina, the girl who was taken by Children's Hospital. We're starting to see doctors being granted, in the case of minors, state authority based on their education experience, and that is terrifying to me. That a doctor is given the power, or at least imbued with the power of the state, as far as some of these decisions go.
Yeah, I don't really know how that really makes sense on a fundamental level, because one of the premises of medicine is this idea of informed consent.
Right.
Like I'm an adult, and every time I've ever been to the doctor in the history of time, the doctor can write me a prescription, but I'm the one who filled it. One time when I had a surgery, they didn't just haul me into the room. There were several forms to sign.
They didn't?
And make it, no, then they in fact actually informed me in somewhat excruciating detail several times exactly what they were going to do, and made sure that I was okay with it. It was a little bit repetitive, but I think there's reasons for that on the hospital protocol level. But anyways, it's not like they made me. So the idea of this doctor says, well, this is a thing you can do, and one of the things I can do is say, no, how about I'm not going to do that because I don't want to. And so normally with a child, as I was pointing out to someone else, a child can't get a tattoo.
Right.
A tattoo is like a permanent thing. And
what if a doctor?
The reason they can't is because they don't have the mental state to be able to give the consent. They don't have consent.
Okay. What if a doctor ordered a tattoo?
I don't know. I don't understand it, because I don't get it.
I'm trying to come up with the weird exception case where a doctor would order a tattoo for a child's well-being. Maybe they have some sort of blemish, and the tattoo would be some way that they could do it, and it for their mental health. But then the parents would have to refuse the tattoo, and then the doctor would have to order the authority of the state to intervene, to be analogous to this sort of situation.
And every medical thing comes with some risk and some reward, and sometimes those are pretty clearly one way or another. But like in the case of transgender, hormone suppressants, or artificial hormones of a different kind than you're supposed to be getting, or surgery, some of the long-term effects of that are unknown. And there seems to be some real risks from that. And so a person could cogently determine that those risks are unworth it. But apparently this parent who's in a position to make that decision, their opinion no longer matters for some reason. I don't know. And my personal favorite question here is because it just runs into logical circles for the government. My personal favorite was, would we find it acceptable if HV dressed like a boy? And I love that question so much. Because my question back is, what is a boy? You tell me, what is a boy?
Right.
Because you are to be able to label something means it has some definition, and it's presumably distinct from other things which would have different labels. So you say that there's this thing called a boy. Please provide a definition for me, government. I'd love to see them turn into knots on that one. That would be super fun.
Yeah, that one, that would be very, that would be a blast. And I loved your take on the video about that was just centered on this idea of, wait, okay, if you're saying that you can dress like a boy, then that means that boys and girls are different. They are distinct from each other, and there is an expectation about what aesthetic each gender would choose. And
Yes.
that's supposed to be, we're supposed to be moving away from that.
Yeah, the very premise like assumes the thing they don't want to say. It's like, would you accept a boy in girls' clothes or a girl in boys' clothes? Like, I'm like, that presupposes that boys and girls exist and are distinct. It presupposes there are girls and boy clothes and they're distinct, which is like these grandparents' point. It's like, we don't really believe in transgender rights because we think boys and girls are distinct. You know who else does? Apparently the state of Washington, implicit in their question. It's like, the logical circles of it. It's trying to square the circle in my mind and I can't make it work. It's like me trying to get out of a loop, and it just can't make I can't make the logic circle work.
It doesn't get there, because I've been to Target before,
Yes.
and I've been to Target specifically, 3 years ago, and as recently as last week. And I know that when I went to Target 3 years ago, they actually had a section called boys' toys, and they had a section called girls' toys. And the boys' toys had a background for the shelves that was blue, and the girls' toys had a subtle pink background on the shelves. And sometime in the past year and a half, they changed that and made all toys gender neutral. So there are no longer boys and girls toys. Now, the toys are still segregated out into the same logistical spaces that they were in. However, they removed the label of boys and girls, and they removed the background. So now you would be confused, I suppose, if you were looking for boys toys, because you wouldn't know by looking at the shelf what toy you were looking at. You'd be like, I don't know if this Transformer is a boy toy or a girl one. I have no idea, because there's no background to tell me. But the court doesn't seem to want to do that, or the state, I should say, doesn't seem to like that idea of gender ambiguity. Right? They want clearly defined roles.
Yeah. And then I took this little, this cheeky note, and I still don't know how cheeky it is, but the policy that they have that deals with making sure that LGBT children are properly accepted and taken care of. The policy that they have internally has a number associated with it. The policy to make sure LGBTQ children are accepted and loved. And the policy number, it's policy number 6900.
Of course it is. I'm just surprised it's not 69,420.
6900. The policy dealing with LGBTQ acceptance. And I'm like, okay, what is the probability that this was just a random number, just randomly assigned? Or what's the probability that in the alternative, this was picked because of the association between this number and certain prurient activities? I'm going with option 2.
Oh yeah.
I think they picked a number 6900, policy 6900, to help the LGBTQ children. That's just super great.
Yeah,
policy 6900, by the way, just in case you want to know for the record, says the following: a child or youth who identifies as LGBTQ will not be subjected to discrimination or harassment on the basis of actual perceived sex, sexual orientation, gender identity, or gender expression.
Well, there you go. And for what it's worth, I think that's a fair policy, right? Like, the child shouldn't be discriminated against by the state based on that sort of thing. I'm not entirely sure that children are mentally competent to understand a gender identity or what it is and to definitively pick it, but that's okay. I mean, who am I? I'm just a guy.
In the context of a 4-month-old, I'm not even sure what some of these terms mean. Perceived sex of a 4-month-old. What does that even mean?
Well, why don't we just ask the 4-month-old?
Sexual orientation, gender identity, or gender expression of a 4-month-old. What do these terms even mean in the context of a 4-month-old? I don't even understand what they mean.
Yeah, it's it's an interesting sort of place. Like, and again, so it makes you wonder. And this isn't really a better case for the state, but Are these just bog standard questions? Like, have they developed a questionnaire about fitness for foster care and they apply it regardless of the age of the child? Right? So, like, let's say this child was 4 months old or this child's 14. They have the same set of questions.
I mean, possibly yes, but I mean, as was pointed out, it's their own biological great grandchild.
Right.
And as you point out, there's this general preference to put people with their own family. And you know, before child services was invented, people just kind of did this naturally. You know, parents would take over, or uncles or whatever. This was just kind of the normal thing. And so the fact that the state feels the need to interject themselves in that is also weird. And then, of course, the really disturbing thing for me is if we are denying the right of these great grandparents to foster care their own great granddaughter on LGBTQ acceptance, what's the next logical step? And the next logical step is knocking on the door of a parent of their own child,
right,
who was 4 months old, and asking, you know, do you support the LGBT mantra? And if the answer is no, they threaten to take their kid away. It's like, how many steps are we away from that? And I'm like, well, not that many, man. I'm reading. This is like actually happening. And it's like, how long is it before, you know, before you take your kid home, born in the hospital, and before they let you leave, that you have to answer some questions. And one of the questions is, what are your thoughts on LGBT? And if you answer wrongly, they take away your 2-week-old because you're unfit to be a parent. And it's like, if you think that's ridiculous, I'm like, I don't think you're fully paying attention to the case. And as I said, like, yeah. 10 years ago, the left said that this was the fever dream of the conservatives, that this would never happen, you know, that they never be trying to, it was just about acceptance and all the rest of it. They never be trying to take kids away from their parents. And I'm like, well, I told you so, but it doesn't make me feel better.
Yeah. It's, again, we've gotten rid of a slippery slope and we're just now at a cliff ready to be shoved off. That's the logic train of government, at this point, because there's really, like, if we're doing this with a 4-year-old, then we've lost all sense of, discernment and reason, or 4-month-old.
Not 4-year-old.
Yeah.
You had to correct yourself on that one.
But
Yeah.
we've lost all sense of discernment and reason in the process. And because it just doesn't make sense. Again, I go back to this idea of, you know, what are you going to do if the child is LGBTQ? And I think one of the things you brought up is, well, you know, statistically, that's a lower probability sort of proposition. I mean, they might end up being gay or transgender or whatever, but the odds of that happening are actually not in, you know, we're not even close to that at this point, with no sort of expression going on from a 4-month-old. I don't think. I mean, maybe they're fabulous. Like, every time you see the little baby, you're like, man, this kid is always dressed so well. Like, what is happening?
Is there a fabulous way to burp? I don't know. These are the existential questions I didn't know I needed answers to. Yeah.
So what was the result in this case? Because it sounded like they determined that the state was in the wrong here.
Yeah, they did decide it was in the wrong. So the court overturned the agency action. So they didn't even remand it. They reversed the agency and basically commanded them to give the foster child to this couple, which is all well and good for this particular couple. But then the court has some language in here speaking to the future, which basically says that, I was trying to find the exact language because I have it up, but basically saying that, you know, you can't use the animus to religion as a reason to discriminate, because that was the real basis, was the discrimination and animus to religion. And the problem here is, and the court doesn't seem to acknowledge it, is that that's just inviting the state to come up with pretext.
Right.
You know, we're not discriminating because they're anti-LGBT or Christian. We're discriminating because, I don't know,
because it's in the best interest of the
parents, because they've been parents in 70 years, and we'll come with something.
Right.
You know,
it should. Well, and the question would be, one of the things you brought up is that apparently in their policy, in their policies and procedures, there isn't a protection for religious beliefs.
No, it isn't
just,
even. It isn't even the policy when it deals with the. There in the policy it does say the foster parents have to make sure to attend to the needs of the religion of the child. So they do
right.
use the word religion there when talking about the religion of the child's religious needs. But when they talk about discriminating against foster parents, they have some great language here, and they do it twice, where they use this wonderful language, and I'll see if I can find it exactly. But they go through the whole list of things, and religion is just noticeably, horribly absent. It's like you can't discriminate. You can't discriminate on the basis of veteran status. You can't discriminate on the basis of if they're being disabled. You can't discriminate on the basis of them having a seeing eye dog that's actually explicitly mentioned for some reason.
That was a weird one.
Yeah. Okay. Yeah. You can't discriminate. Okay. Child administration is prohibited from denying any person the opportunity to become a foster parent on the following reasons: race, creed, color, national origin, gender, honorably discharged veteran or military status, sexual orientation, or the presence of any sensory, mental, or physical disability. So if they're insane, that's not a problem. Or the use of a trained dog, guide, or service animal. And then it's like I said on my video, what thing is normally in this list that is conspicuously absent from the list? When we talk about race, creed, color, national origin, what thing is in the list? It's conspicuously absent. It's like religion would be the thing that's conspicuously absent. We've got it. If they're blind, that'd be sensory. If they're blind, no problem. If they're deaf, no problem. If they have mental disabilities,
look, Helen,
cognitively impaired, or
Helen
insane,
Keller,
no, they're physically disabled, they're in a wheelchair, no problem. But heaven forbid they have a religion or don't speak to the one true LGBTQ faith. That's a no-no.
Look, Helen Keller can take your kid, but if you think that that 15 years from now you might not be comfortable with hormone replacement therapy due to your religious beliefs, no, not a chance. Can you raise this child, bigot?
Yeah. No, you can be literally gay, blind, incompetent with a guide dog who might eat the kid, and that's all okay. But if you have religious reasons, then not so much. And then the court ends somewhere with basically saying it can't be. Where is it? They can't use the. Okay, here it is. The court does not enjoin the department from taking LGBTQ considerations into account when reviewing foster care licenses, but a foster care applicant's answers to LGBTQ hypotheticals cannot serve as the sole, and they took the effort to put the word sole in italics, so they're bolding it, the sole determining factor when applicant expresses sincerely held religious beliefs. So what does that tell me? When you use the word soul and you put it in bold,
just gotta add some other stuff.
Come up any reason. They're old, they're lame. Not literally lame, because that'd be a physical disability. They're not with it. It's like, oh my God. So yeah, and then it says the department must make reasonable accommodations for religion. It's like, yeah, I'm definitely feeling like that's a thing that's about to happen here in Washington. I'm really feeling that child services here is just couldn't be more thrilled with reading this language and like, I'm going to give all the reasonable accommodation. I couldn't believe I've seen the light. I'm like, that, yeah.
It reminds me of the Supreme Court decision in the bakery, right? The Christian bakery.
Oh yeah. Master Case.
Where the Supreme Court said the only reason that they were overturning the case was because at no point at all did anyone roll back the overt animus towards his religion. But that was it. They were like, if they had anything other than disregarding or disrespecting his religion openly, we probably say bake the cake. But because they didn't do that minimum thing of just saying, we respect your religious beliefs, but bake the cake. If they would have said that, the Supreme Court would have been on their side. That's what's dripping out of that entire opinion. And that's what comes through here. It's like, look, you denied these people based solely on their religious beliefs, so you got to give them the kid. But the next person, idiot, just come up with anything to accompany the religious test, and you'll be
just
okay.
In case, it's like, just in case you were thick, they took the time to put the word soul, in italics to make sure, just in case you didn't miss that reason. It's like, we didn't want you to miss it. It's like, yeah, my word. So yeah, the transgender rights of 4-month-olds are alive and well in the great state of Washington. Fantastic.
It's a good one. How did you find this case?
I just have various legal sites I go to. There's a whole bunch of sites. I have various alerts on Google alerts, and then I troll Slashdot, troll Reddit, Above the Law, Volt Conspiracy, How Appealing. There's a couple other ones where I get cases from, and this was just one that popped up in my feed, and I'm like, yeah. So,
it's a good one. Okay, so bad,
and by good we mean absolutely horrible and atrocious train wreck.
Yeah. Oh, it's horrifying, but it's a good case to cover because it does demonstrate that there's a reason people have fears about, the sort of slippery slope idea. There's a reason people have fears about the progression of progressive policies in certain ways. And when your deeply held beliefs are I guess implicated by those policies, like, maybe take a second and just empathize with the person and say, why do they think that gay marriage will lead to normalizing minor attracted persons? Well, I mean, maybe there's an argument that it has. Or why do they think that the gender identity stuff or just bathrooms in schools is going to lead to real implications? Because, well, now we're saying that great-grandparents can't have access to their great-grandchild if they aren't full-throated support of the LGBTQ, of one aspect of the LGBTQ idea. It's because that's the other thing. This isn't a monolithic group. Like, they not all LGBTQ, all of the other letters, people believe and act in the same way, and they don't all believe the same thing. For example, there are trans people in my Discord who do not support the idea that children can be transgender based on their own experiences. It's like, no, that's I might have had ideas about identity or expression when I was younger, but I needed to wait until I was mature to make the decisions about how I would change my body, for example, right? Like, that's kind of an idea that's out there. And so it's not a monolith, but they're treated as a monolithic block, which is great. I always enjoy using people for my own political ends. So kudos.
We can move on to something else so my probability of having a stroke goes down.
Okay, there's 2 questions related to this specific subject. Bad Vibe says, the real irritating aspect of this slippery slope is there are individuals asking for the last phase, maps being active, that people said was coming, and LGBT groups called crazy. This is ridiculous.
One of these days, someone on the left has to explain to me what their definition of woman is, because they say is trans woman a woman? I'm like, what's a woman? Oh, okay.
I think we're back.
Did the YouTube let us join? Oh, good. Yeah.
Yeah. I sent Susan $50 and an apology. And I said, we will never disrespect the LGBTQ plus TIA plus AARP community ever again. I will never, ever disrespect or denigrate anything. And the religious bigots who are trying to raise that child should have it taken away immediately so it can properly become a boy or girl of its choosing.
I got nothing left.
Oh my God. All right, let's move on to Supreme Court or Billy Mitchell. What do you want to talk about?
I don't care. Either one's fine.
You look a little bit down, my friend.
It's so depressing. It's like looking at the horror show and you're looking into the black void and you're like, yep. It's like maybe the whiskey will make it better. So it's like, yeah, we can talk. Let's talk about Billy Mitchell. It's less likely to be completely depressing.
Yeah. Okay. So I did a video on this earlier today, guys. A short video. You can go check it out if you want. Long story short, or short story short, I suppose. Billy Mitchell is moving forward. He has passed the California anti-SLAPP motion in his lawsuit against Twin Galaxies. My video drew the attention of a speedrunner by the name of Carl Jobst. I don't know how to pronounce his last name. Seems like a nice guy, decent sized channel, bigger than mine, and he is not a fan of Billy Mitchell at all, and he believes that he is a liar and a cheater, as far as I can tell. Mm-hmm. This reminds me of our conversation about Floyd, because the interesting thing about this is it does matter at some level if Billy Mitchell cheated.
Mm-hmm.
However, the legal standard for defamation, they didn't say Billy Mitchell cheated. They gave a very specific, because that would be an opinion. They gave a very specific set of facts that led people to the implication that Billy Mitchell cheated. If he can disprove those specific facts, and he can show that they made those statements with knowledge of their falsity or reckless disregard for the truthfulness of them, then he can win the lawsuit whether or not he actually cheated. Does that makes a weird sort of sense?
Well, I mean, the ultimate truth or falsity is going to be an element of it. So whoever the trier of fact is going to have to try to determine whether or not it was true or false based on whatever evidence they're going to come up with.
Right.
So they're going to have to, I mean, that's what juries are for. Is it true or false? Well, ask a jury and they'll tell us. They will reveal the truth. Yay. So
they have the 8 balls to do it.
Yeah. So, the statement was essentially that he didn't use sanctioned hardware. He didn't use the, unaltered board from the Donkey Kong or Pac-Man machine, as the case were, to generate his results, and may have used something else. And the suggestion was that he had used MAME, although the version of MAME that they were talking about didn't exist at the time, but it has very similar artifacting features to the one that's on MAME. So the idea is he was using some kind of emulator to generate it. Right. And the element that I thought was weakest in the court's analysis was actually going to the reckless disregard of the truth, because Twin Galaxy did do a fairly extensive investigation, and there were flaws, to be sure. They hired a private investigator, but he has apparently expressed some strong animus in the start, so he wasn't neutral. The guy decided to discount any oral testimony of things that they observed and just were trying to go on technical aspects, although they then went and looked at testimony from people that were unaffiliated with Billy on the other side, so they broke their own rule and stuff like that. But I think so there's that problem. But on the other hand, they did have a fair amount of evidence that was presented, and they did have an open discussion in their forum, and they did invite Billy to participate, and he didn't. And not that he necessarily had to. So was it really reckless? That was the weakest part of the opinion for me. I think I might have gone the other way if I were writing the opinion on that.
One of the things I found interesting was in regards to the actual malice standard, reckless disregard or knowing falsity. California law, according to this judge in his citation, allows for circumstantial evidence of a party's animus towards the other party to draw an inference that they didn't do the investigation complete, or that they didn't make a proper inquiry because they don't like the other party. Whereas Texas, for example, does not allow like that. Like you have to show you have to show more than just an inference that the person doesn't like you. You have to provide a reason why they would have would not have the knowledge. And one of them was, the intentional choosing of sources that are unfriendly to the other party. And so that, of course, is kind of how the court got there, by saying that, well, you talked to these people, but you wouldn't talk to Billy's people. You knew that these people were negative towards him, and therefore you didn't look for anybody who was positive. One of the good lines in the opinion in regards to this was that it said Twin Galaxies does have a rule for how evidence is to be submitted for their investigation, but they haven't made a good legal case as to why that should have any legal bearing on the defamation.
Yeah, I kind of understood. I kind of half understood what the court was saying. It's like, just because you have a procedure doesn't mean that, it's fair, because you could imagine a procedure that would be like definitionally just completely unfair. If the idea is, reckless disregard of the truth, and my internal procedure is,
I only talk to the other party's ex-wives.
I believe all the lies. Just because I follow my own rule doesn't mean it's not necessarily going to get me by. So I appreciated that. But, on the other hand, it's not the government. They're not required to give you really due process. So were there some problems in the investigation? Yes. But, there were some other things that helped them. So I don't know. I felt that was a little bit weak for my taste in terms of the whether or not they had the reckless disregard for the truth. And I doubt that they really knew for a fact. I doubt that's true, because they had evidence as strong as they apparently at least said that they tried to regenerate it. They got the original board, and they got the capture device that they think he used, because he was trying to get a signal from the board. And this is like 1970s technology. So you have to get something to actually like split the signal off the board. And so they used the appropriate thing that existed at the time and tried to recreate this thing, and they couldn't do it. They couldn't recreate the artifacts that they saw in the recording through their efforts. So, that's not nothing. And it felt like, I don't know. I had some issues with that on the, what did you think? Did you think the court was right?
I hate anti-SLAPP provisions. I don't think they serve the purpose that they're intended to serve. In fact, I think they do the opposite.
Tell me more.
So an anti-SLAPP is such a devastating remedy, and it's meant to curb the cost of frivolous litigation. But oftentimes, it is in many states, especially in Texas, it's a path to automatic appeal. So it doesn't reduce the cost of frivolous litigation or the time. In fact, it almost exacerbates it by having an automatic appeal, because you may as well, no matter which party you are, right? Like if you lose the anti-SLAPP and you have even close, like, Twin Galaxies should appeal this based, if nothing else, based on the actual malice standard. They should say, whoa, he has presented no evidence of actual malice. All he's done is presented evidence that this guy doesn't like him, but that's not actual malice. And the Supreme Court has been very clear that actual malice is not just malicious behavior. It is these specific things: reckless disregard for the truth or knowledge of the falsity. We did a very thorough investigation, blah, blah, blah. They should appeal it. But on the other hand, if it would have gone the other way, Billy should absolutely appeal it, because the result is devastating. It's complete. And I think it's an overtly prejudicial determination to determine the sufficiency of evidence without having a fact finder weigh the evidence. That bothers me, because it's ripe for abuse from judges to say, well, this isn't a prima facie showing because it's not enough evidence. It's like, well, wait a minute. I thought we weren't actually measuring the sufficiency of evidence, rather that there is any. So with that, I see them as almost an automatic appeal, which adds cost, it adds time, it bogs down the appeals court with these things. And in Texas, I mean, and I haven't looked at California, I'd imagine it to be similar, but in Texas, you can find TCPA cases going to the appeals courts and coming back down from them both ways constantly because the judges just can't figure it out. So I hate anti-SLAPPs. I'm glad he passed it for that reason alone. I'm not particularly invested in whether or not Billy Mitchell wins his lawsuit. I don't care. What I do like to see, though, is two things. One, I like to see anti-SLAPPs fail. Two, I like to see a pushback against the idea, and this is mentioned in the court, that we can just post things on the internet and not be held responsible for the real damage that it does. Because no matter what you think about Billy, no matter what you think about him, he has a demonstrable amount of real damage from this. And if it is false, he deserves to have that. He deserves to hear that out. I don't know. I don't know if it's false. I'm hoping Carl, when he comes on, he's on Monday, by the way. Carl Jobst will be on Monday. We'll be talking about this suit and the whole thing. We're going to be talking about the technical aspects of it because that's what I don't understand. I mean, I can read from the document, but I want to know from someone who's in that world kind of what competitive video gaming looks like and how they did it. Because my understanding is that basically two guys on the internet. I don't know anything about these two guys. I don't know if they have any affiliation with Twin Galaxies or any credentials to do this, other than what they may have said. They looked at the tape of the run, determined that there was an artifact that, for whatever reason, they determined couldn't be reproduced on an original PCB, and therefore he must have used an emulator. But that's not, don't get me wrong, but from a legal perspective, that's not actually conclusive that he used an emulator. That's just that they couldn't replicate something that they saw, and they then determined based on their failure to replicate that he must have done something else. But of course, if you take Billy's statement that he had an actual engineer from Nintendo, presumably familiar with the original PCB, verify it, and the Twin Galaxies refused to look at it or to talk to that guy. I mean, again, as the court had to do in the motion, taking it in the way most favorable to Billy, well, that seems completely unfair. So I don't know what the answer is, and I don't think in a case like this that an anti-SLAPP is a proper place to figure it out. It seems like we have, see, this is why I like summary judgment as a pretrial standard, because with summary judgment, okay, we have genuine issues of material fact. This person, we have someone here, not just the person's own word, but we have someone else attesting to the fact that he didn't use the thing that they're saying he used, and they say, well, no, he must have used this other thing. So that's a genuine issue of material fact. Summary judgment isn't proper. So at that point, I say not frivolous. Now he may lose, he may owe fees from all of that stuff, and that's fine and good. If he cheated and then you know, let him hang his own hat, so to speak. But that's kind of where I come down on it.
Well, I think you make a good point, especially about the Nintendo engineer, that maybe that analysis makes more sense now. But as to the underlying issue of an anti-SLAPP, I mean, to my mind, it's just creating a new motion to dismiss. So I don't perceive the anti-SLAPP as anything more than just a variant of the motion to dismiss. You know, the motion to dismiss for failure to state a claim, motion to dismiss for failure to bring, you know, the bare minimum quantum to get to there. So it's just a variant of the motion to dismiss, basically. And so we're trying to solve a problem, which is people are suing people because they don't like what they're saying, and they're trying to use court processes improperly as a mechanism to, you know, create such court costs that they'll back down in the first place or to ruin them. You know, if you know it's going to cost $50,000 or $100,000 to go to court to fight it, you know, then you're much less likely to fight it. So I'm not arguing necessarily that the anti-SLAPP in California or Texas is the end all be all, but the fundamental idea makes sense. You know, I'm a big proponent of freedom of speech, a big proponent of people's right to speak. and I get a little bit pissy when anyone, including other individuals, trying to infringe on my freedom of speech. You know, my rights end where your rights begin, and so forth and so on, right?
Right.
So like whatever your rights are, they don't infringe on mine. So if you're coming after me trying to silence me, illegitimate me, I'm going to get a little pissy. And under the old dismissal, you know, I wouldn't necessarily get attorney's fees. It would be very rare for me to get attorney's fees. So I might be $50,000 or $80,000 in the hole and never get any of that back. So I think the anti-SLAPPs are fundamentally a good idea, if whatever weaknesses they might have.
If the anti-SLAPPs just provided a remedy where if this thing implicates the First Amendment, you're entitled to attorney's fees on victory, I'm fine with it. Even if that victory comes at a pretrial dismissal. The issues that I have are with the discovery stay in Texas, I think is a mess. It's one, it's prejudicial. Two, it's just a messy implementation. I have problems with that. And then this clear and convincing evidence standard, which is not, clear and specific, not clear and convincing.
That's right.
Right.
Yeah, I make that mistake all the time too.
Right. And so do judges. But it's this clear and specific evidence, which is, it's not a new standard of evidence, but it kind of is. And it's this idea that it's prima facie, but it's beyond prima facie a little bit. And so it's like, I don't like having the heightened standard, because if we have existing mechanisms for pretrial dismissal and then summary judgment and then full trial, I don't see why we need to create a new thing with a separate standard to do that if we're just creating the remedy. I'm all on board with the remedy, and I think loser pays litigation is actually I'm not 100% loser pays, because I can see where that is a very prejudicial sort of thing for some people, and it can have a chilling effect on rights. But some notion of expanding the idea of loser pays into various avenues, I'm all for it. I'm all for that sort of tort reform. But yeah, I have problems with something where it's also become so easy to really damage someone with speech now, in a way where, when a lot of this stuff was kind of contemplated and created, especially defamation law generally, it was hard to do it. Beyond, like, you had to, like, if I wanted to hurt your reputation in 1975, I had to go around and try. Like, I had to shop your story out to new media or to news media, or I had to get on public access and blast you live, or I had to literally go around and talk person to person. But today, someone can do this on Twitter. I don't know. It just sort of seems like this person is touching people in sexual ways, and suddenly, like, their whole career can be over. And I'm like, there's something wrong with that too. Cause we do have a right to our reputations, to our own control over those reputations. And so if someone does lie to you, you're right. Your rights begin where my rights end, or my rights end where yours begin, or whatever the saying is. But that does go both ways. So that's where I have the problem. I think it's a messy system. So I want to see more cases get past anti-SLAPPs, with the hopes that maybe they'll start to see the difficulties of implementing the system, and maybe revise it for a more fine-tuned use, if that makes sense.
Yeah, I don't necessarily have any objection to this, and then we're just into the weeds on policy of trying to figure out how to balance all these policy considerations.
Yeah,
and going and writing different statutes. So is the TCPA the end all be all? No. Is the current CDA the end all be all? No. And then it just becomes an issue of how do we balance these policy considerations and write a better statute. So I have no objection to trying to reform it and make it better. So that's fine. You want to talk about our fears on the Supreme Court and the new hellscape we're entering, where federalism itself is being threatened and the sanctity of the republic is but a memory?
Yes, that sounds like riveting and uplifting conversation that I would love to have. I don't want to. Hold on just a moment. Okay, I think I'm more ready for it now. All right. let's start with this. Of course, Amy Coney Barrett was confirmed. There was much hand wringing over her lack of using herself from all decisions, which was stream's buffering again. No, it's back. It's back. Okay. So there was
you mentioned her. You mentioned her name. You mentioned her name, and it buffered.
Susan, I'm sorry. I will no longer call her by name. I will not invoke her true name anymore.
What you meant to say is Alexandria Ocasio-Cortez, right?
Yes.
Right? Okay.
Definitely AOC, who we're talking about. So there was much to be made over her refusal to commit to recusing herself from any case categorically that Democrats wanted her to commit to at confirmation, which would have been completely improper, in my opinion, for her to commit to recusal, because recusal is something that you determine based on the case itself. That's just how I see it, and it should be a fact and case specific question. Now, their fears about her ruling in Pennsylvania and North Carolina were alleviated when she took no part in the decision at all. So she didn't officially recuse herself. She just didn't take any part in the decision at all. So that was fine. So we could see, and this is what I had said during her hearing was, I think that it's likely that at least in some of these cases, she will recuse herself for the appearance of impropriety, but to demand it was a bit much. So she did that. And actually the Pennsylvania case, which she didn't participate in, she was asked to recuse herself, but did you see that they withdrew?
Yeah, they withdrew it. That's hilarious. Yeah.
Yeah. The city council's like, whoa. What are you doing? What are you doing? But it ended up not mattering in the long run, because she didn't participate in those questions. Although my understanding of Pennsylvania is that the court is actually reserving the question in Pennsylvania, and they're prepared to give limited relief to demand that Pennsylvania maintain and segregate late received ballots. And if there is an allegation or a recount, basically, they will then step into that issue, and will be able to rule on it at that point. But they have currently said, we're not going to deny the acceptance of these ballots late, but we ask that they be segregated in case there's a challenge to them later. So I think we can reasonably ascertain that if Pennsylvania is in play at all, that will be brought before the court.
Yeah.
But so that happened. So we now have ACB, and I only bring her up for one preliminary conversation before we get to the full court stacking. And I had a problem with the partisan vote to confirm, because in my opinion, you have two votes that matter, two opportunities. One, if you're objecting to the process that's going on, and that's the thing that Republicans won back in 2016. They objected to the process of nominating a new Supreme Court justice, and they, in control of the Senate, were able to win and shut down Merrick, or whatever his name is, Merrick Garland. This year, of course, Republicans still have control of the Senate, and they win on the process. So I think once you have passed that process stage, that it is your duty as a senator to vote based on the merits of the candidate rather than voting on the process for the confirmation vote. So I wanted to get your philosophical perspective on that.
Well, I'm still working through my philosophical perspective on that, to be quite honest, because for a long time there weren't hearings at all. There weren't hearings. They just confirmed nominees. And then, of course, for a long time, nominees were confirmed unanimously or close to it.
Scalia.
Ginsburg and Scalia were both, Ginsburg was like 96 votes. Scalia was 97 votes. Like you can't imagine that ever happening again. And it all probably started with Bork going down the other way. But
effing
it's
Bork.
It's hard to imagine now it's like, what is the real role of what is the role of a senator supposed to be in terms of the confirmation? Because I'm trying to think, if I remember the Senate was my philosophical position, because I could take the position that I should only justices who I think have the right legal philosophy, which is going to be originalist or more textualist. You know, I like Gorsuch these days, so I'd be looking for people who are similar to Gorsuch. And if you put up a more left leaning, living constitutionalist person, I wouldn't favor them. So should I be, voting because they're smart, well qualified, they know what they're doing, they're thoughtful, but they have the wrong philosophy? Should I be confirming them? It's like in the old days we'd say yes, but now it's no. So it's like, what is my role here? So to the extent the Democrats are voting against her because they disagree with her philosophy, then I'm trying to figure out the degree to which that's legitimate or not, and I haven't figured it out yet.
Rand Paul talked about this a couple years ago. I don't remember who was being confirmed at the time. He was opposed to the person. However, they asked him, they're like, Rand, what are you going to do? And he said, I'm going to vote yes. He may have even done like a filibuster on this person. I don't remember. But he said, I'm going to vote yes because my constitutional obligation is to provide advice and consent. It's like, so he read the constitutional clause as an affirmative duty to consent to the president's nomination, but to provide advice. So the hearing or confirmation process would merely be to generate that advice, I guess. Like, here's this person's judicial philosophy, so you need to know about it, but I'm ultimately going to confirm it. I'm not sure I'm with him on that. I don't think that that's right. But I do think with the Supreme Court justice, I'm also not at the point where I go, their judicial philosophy is opposite of mine, so I don't think they're fit for the court. Because I'm more of the opinion, like, I don't like Ginsburg's opinions, right?
Mm-hmm.
I don't come to the same legal conclusion she does. However, I'd have a hard time questioning her credentials to be on the court, her capability.
Yep.
Like, she wasn't an idiot. She was just wrong, in my opinion. And I was watching her eulogy to Scalia, and someone had asked Scalia how he could be friends with her, and he said, lots of great people have really bad ideas. So, but that was, that's the idea. It's like you can have a great judge, you can have a judge with who's, or you can, and they can have bad ideas, and I think that's okay. I think our system is meant to absorb some of that if they are qualified to do it. Now, if they're incompetent, if they have real character issues, if they have conflicts of interest that put them beyond the scope of their position, that's a different story. But I think once you get past the idea that we're going to nominate someone, you go based on their education, their experience, and their ability. And once you have that, I think you gotta vote for them. Now, I think people could reasonably question ACB, say, hey, look, I really think that a qualification to be on the Supreme Court is to be a trial, a litigator who has actually argued before the Supreme Court or before an appellate court. And I don't know that she ever did that. I mean, she was on the appeals court,
So.
but yeah,
I don't think she ever argued a case.
So I think you could. I don't necessarily agree that that's the proper way to do it, but I could see that someone could, right? Like, you got to be a trial lawyer. That's what we want on the court. So I think there are ways that people could reasonably object to ACB. I just didn't see them doing their objections on that. To me, it was all an objection to the idea that she was being confirmed when they were out of power. That was.
I did take a little bit of a note or schadenfreude at some of the more left-leaning people on like Reddit or otherwise who are like, the feminist forums, who are like, women everywhere, women in all fields, but not this woman. And
right.
something very satisfying about her being sworn in by Clarence Thomas, because we want black people, but not this black person because he has the wrong view. So it's like something just very satisfying about that on a very visceral level. I think she's going to be a very good justice, from what I could tell, from her answers and her philosophy. It sounds right down the line to me. It'll be interesting to see where she comes out on different things, but I think she's probably going to be somewhere around Alito in terms of philosophy. I think that'll be fun. And so Roberts can now hang out with the libs, and that's fine. Now we have someone who actually give a damn and bring it to the concern. It is also funny. It's also just a little bit funny because, as I'm sure you well know, the court has been left leaning for a very long time.
Oh
in
yeah.
terms of like most of the metrics, and so the Democrats were super cool with it for 70, 80 years when it's been left leaning, and the Republicans finally get control. It's like, this is unacceptable. We must reform.
Right.
The conservatives finally have the court. This is an abomination. They'll take away our rights to the health care and the abortion. I'm like, you could pass a better law. There's always that option, but okay.
Right. That's I've been listening to a lot of Scalia lately, and that's one thing I liked about him so much, is explaining what the Bill of Rights were, what the Constitution is. It was using democracy, or the democratic process, to take things away from the democratic process. And so he said that's what gives the Bill of Rights validity, is that the majority can't just vote on gun rights because the majority already voted and said, nope, gun rights are sacrosanct. So now to get a different idea about what gun rights are, you would have to amend the Constitution. So you'd have to get that super majority. You'd have to get a bunch of buy-in, and it's a big process. But he says when judges do it, there isn't a democratic process to remove something and cement it. And he says Roe versus Wade wasn't this idea of expanding rights or whatever, because you could already do that. Any state could have passed a law at any time before Roe versus Wade to make abortion legal. At any time they could have done it, and there would have been nothing anybody could do. Same with the death penalty.
Right.
If you don't,
Scalia made that point clear. It's like, I don't necessarily think the death penalty is necessarily a great idea. You want to repeal it? That's great. A lot of states have, no problem. Scalia's like, yeah, that's fine.
Right. But to go through the Eighth Amendment and say, well, the death penalty is cruel and unusual punishment, when it clearly was not when the Eighth Amendment was adopted, is to just determine that you don't like the death penalty and rule on that. That's not how that is supposed to work. There was a process for laying these things out, and that's the idea of what originalism or textualism says. It's like, no, these are specific. There was reasoning behind them, and to expand them beyond that is silly. Why don't we just pass a law?
Yeah, one of the things I don't quite understand from like some of the left-leaning people on like their thought in the court is like, if Congress writes a law today, if they write a law today and they pass a law today, do they not want me to respect the law they passed? Do they not want me to actually like look at the words they wrote and apply them? If the Democratic House writes a bill and they can get the Senate to pass it, the Democrats don't want me to actually look at the bill and apply the words that they wrote. They don't want me to give them that respect. I don't understand the argument. It's a very strange argument to me.
Yeah, it's it bothers me. It bothers me very much. And Scalia in a debate with Breyer, basically.
I love that debate in Arizona.
I think it was, where he's
it
like,
was a great one. It was great.
Where he says, with originalism, you have a concrete idea of how they wanted things to be, to measure things by, and with the evolving theory, you have nothing. and he nails it. So, but I bring up ACB because the partisan divide bothers me, because now we have a 52-48 justice, and I have a feeling that will fuel into the argument that she is illegitimate, and therefore we must now pack the court, which is what we were talking about here.
So that is one of those things that I find to be absolutely, truly terrifying in terms of the stability of the republic. The idea of packing the court and creating a whole bunch of seats that would be filled by one party for purely political ends, because the three branches of government are currently sitting in a balance, and that balance has been in place for a long time. The members of House have been set since 1905 or 1908 or something like that. The members of the Supreme Court have been set since 1860. And so there's this balance that's in place between them. And then, of course, there's also the balance between the states and federal government. in the federalism bounce, which is, always tenuous, but there's that bounce in place. And it's very hard for me to see. And also another thing I talk about a lot is the separation between politics and law. And you talk about this on your own channel too.
Yeah.
You talk about it for impeachment, where you say this is not a legal process. This is political.
Right.
It's a separation between politics and law as separate concepts. And it's very hard for me to see how you stack the court and it doesn't lead to a couple of things. It doesn't lead to that becoming a truly political branch, which then, according to the Federalist, what's the point of it? Because it doesn't have a purpose for existence anymore.
Mm-hmm.
So it becomes a political branch. It upsets the balance of powers between the three branches of government on the federal level. And then, because of the illegitimacy in this new super legislature, to the extent that they're overruling things on the state, I think it threatens the federalism balance. Like if the Supreme Court just starts basically enacting legislation from on high, I think some states will be like, well, we didn't really sign up for this. And I think it threatens the solvency of all these structures. So I think it's an existential structural threat. And it's about one of the most destructive things I can imagine doing.
So how do you think, because we talked about this right before the show started, but I want to continue that discussion. How do you think the method of packing or stacking or whatever the court, what do you think it looks like? Because there's always just the idea that, okay, we have a 6-3 split ostensibly of Republican appointees versus Democrat appointees. So the prudential approach would be to appoint 4 Democrat appointed judges to guarantee you will drown out the conservative judges or the Republican appointees, ignoring the popular sentiments about Roberts right now and just assuming that Republican versus Democrat is what matters. So you appoint 4 democratically appointed judges. Now you have a 7-6 majority. And that's kind of the idea. But it doesn't sound like you think that's how they would approach it.
I mean, I couldn't speak to exactly what they would do in terms of that, whether they change it to 11 or change it to 13 or some other number. But I think what they do is they change it to whatever number they're going to, appoint the seats, and then change it back to 9. And then, once people die off or resign, those seats would expire. And they've done that before because the Supreme Court was 10 at one point, and then they changed it back to 9. That was 150 years ago, but still. So you and then the seat just expires when it expires. So that would be the idea. So you put on these 4 new justices or whatever, or 6 new justices, change it back to 9. And even if the Republicans get control of the Senate, unless they can also get control of the House, unless they can get all 3, House, President, and Senate, they can't pass a law to repack the court. So they're stuck with, their legal eagle judges that they were able to appoint.
Yeah.
So,
legal Devin for Supreme Court.
That'd be good.
God.
That'd be good.
God save us. Okay. So we should probably talk about the process that you're talking about, which would be the number of justices is controlled by the Judiciary Act of 1860 or whatever it was. I don't remember when it was, but somewhere in that time frame. And that says, it used to say 6 justices, then it said 9. For some point it was 10, you said?
Yeah, it was 10 at one point.
Okay. But they settled on 9, and it's been 9 for a very, very long time. So one way to change this is to, if you have the House and the Senate and the presidency, you can merely pass a bill because it's just a law, and you can modify the Judiciary Act to say whatever number of justices you want. You could say 50. You could say 10. You could say 1,000. It's really, there is no limit. The only limit that we have is just the one that we've been with. So there's no guidance in the Constitution about what it looks like or how many people there should be. We're entirely basing this off of, at the beginning there were 6 and then we needed more. So you would pass that law. So then the worry, I guess, would be that if one party does that, the next time the other party gets power, and if they do it fast enough and it makes people mad enough, that power shift could be quite dramatic.
Yeah, that's possible.
There could be a tide of people going, whoa, we don't like this. they could come in and they could change it to whatever they want, including that's one risk, is like this runaway escalation of justices going back and forth, which would be stupid, and we would eventually end up with a ridiculous court. Or they could limit it back and just wait for people to die and have an agreement that once people die, we don't replace their seats. But if the Democrats were to put a bunch of Democrat justices who are all young and are expected to outlive the conservative justices, the Republicans might not want it to be that way. So that's one way to do it. But I propose to you an alternative possibility, in that I think there's a reasonable assertion to be made that if you have the Senate and the presidency alone, the president can appoint any number of justices that they want, and the Senate can consent and approve any number of justices that the president appoints, because I don't think the Judiciary Act can actually constrain the Senate to 9 justices and the president. What do you think about that?
Well, I'm having a bit of a tough time on that, because the power of the president to nominate is not unique to the Supreme Court or the judiciary. He has the power to nominate for, all the Senate confirmed positions, and the Senate confirmation to advice and consent is the same there too. So if you're thinking about the president's ability to nominate to the executive branch, he can't really nominate to positions that don't exist. He might be able to create some in the executive, but if he wants it recognized by law, there's that too. So,
The
and of course,
distinction.
Article 3 of the Constitution itself says, the number of the inferior courts can be ordained or established. So how many there are in circuit courts, how many trial courts there are, is open to the Congress. So, yeah. And then, of course, the only position that is really specified by the Constitution is the Chief Justice, because it says the Chief Justice shall sit during the impeachment of the president. So it defines that role, but how many other justices there are, it doesn't say. And so, yeah, I'm having a tough time with that theory, but at this point, I'm desperately clinging on to straws. I was trying to conjure some sort of idea that the original power of the Supreme Court extends to public ministers and councils, and that they have original jurisdiction in cases dealing with public ministers and councils. So if they tried to pack the court, the Supreme Court could sua sponte bring an original jurisdiction case before themselves and rule it to be unlegal. I think that'd be super fun.
That'd be interesting. And again, what would they do? And this would be one of those fun power struggles where we've only existed by gentlemanly agreement for so long in all of this. But I want to read Article 3 real quick, which is not very long, or at least the relevant section. So it says, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished. Judicial power shall extend to all. That's that one. Does it say this jurisdictional aspect isn't really important here? Treason against the United States shall consist of blah blah blah. That's it. That's all it says.
That's a little short.
It doesn't even mention the Chief Justice in Article 3.
No, it's not mentioned in Article 3. The only place it's mentioned is in the impeachment clause, which is Article 2 something, maybe.
Right. So, shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. I guess you could argue that Congress would ordain and establish the Supreme Court and the inferior courts based on the wording there.
That would be one way to interpret. I think the inferior courts are the ones that are ordained or established, I think, is the better read. But even then, it's like how many people are in the Supreme Court is not specified. And so if you think about the president's power to make nominations and the sensibility to give advice and consent to those nominations, you still have to ask the question, nominations to what? And because, the inferior courts don't exist unless Congress creates them. The positions that the president appoints to within the executive don't exist unless Congress creates them. So I think the idea that the Congress can't create legislation that deals with the Supreme Court is a bit tenuous. Although, again, then there's also this idea that in generally speaking, each branch of government can do things that's within the four corners of its own branch of government. So the easiest way to illustrate this would be for the legislative branch. So the legislative branch can pass resolutions that honor people because they don't have any external effect. If they want someone to lie in state, they pass a concurrent resolution. It doesn't need to be signed by the president because you lie in state at the Capitol, so it's within the four corners of their building. So there's things that the legislative can do unilaterally, and so can the executive because of his unilateral power. And so the idea would be there might be some things that within the judicial branch that the judicial branch can control. And the judicial branch, to the best of my knowledge, has not really taken advantage of this. But the idea would be if maybe there's some chicanery, the Supreme Court, as I said, could try to bring an original jurisdiction case or use its supervisory power over the lower courts, because the Supreme Court can just sort of dictate at any time to lower courts, like procedures, policies, and various things that are not specified by statute. They have a lot of control in terms of dictating a lot of things to lower courts just on their own regulatory initiative, for lack of a better word. So the idea would be if they play games with the Supreme Court, because the Supreme Court basically say no because it infects the integrity, sovereignty of our branch as a plenary issue of us. So it wouldn't even be the idea of the president ability to nominate and the Senate's ability to confirm your idea. The judiciary say we're just have none of that because it encroaches on our domain. And since our province is to say what the law is, screw you.
Yeah. So then the question is, how far do they want to take it? Right?
Yeah,
because
no.
that becomes the question in a lot of these things is, okay, you say what the law is, but we've said what the law is as well, and you can't check our power and we can't check yours because we have plenary authority to do this, and we have guns and you're arrested for treason. There is that weird possibility that always exists in the back of everyone's mind, is that the president just orders the army to arrest people, and then it's up to the army to actually do it. And then we're in real trouble, of course. We're in real trouble.
Oh no, you get all kinds of constitutional crises. Like Governor Whitmer over here is trying to start constitutional crises in her state of Michigan because she doesn't want to obey her state Supreme Court with their orders. So like we got constitutional crises everywhere where different branches of government are ignoring other branches of government, and the Senate is making nominations and the judiciary says we're not gonna. It says I'm really a justice, and they start writing some shadow opinions. You can get into all kinds of hypotheticals, and then basically it just ends in bloodshed.
Right.
Literally.
I don't want to go to that personally.
No, not really. Not really super ideal.
Yeah.
I really feel like, I never liked the filibuster. I don't care if they want to pass legislation. I don't care. They should anyway. Part of the reason we're in this mess at all is because Congress gave up legislating like a long time ago and said, what if we just gave everything to the executive and let them pass regulations? And then we'll create Chevron, Auer, and Brand X deference so they can rewrite the law anytime they want because we don't give a damn anymore because we can't be bothered. It's like, if Congress actually would do its job and legislate, we wouldn't have this problem. So if they want to get rid of the filibuster because it makes legislating easier, that's fine by me, man. So maybe that's the solution. I don't know. But the idea of packing the court is terrifying to me.
Yeah, because it just... There's a road that you go down in political power, and this is actually one of my concerns with Trump back in 2016. His very, very acclaimed line to Hillary Clinton of "you would be in jail" made me think, okay, that it concerned me a little bit, because while it was a great line, it's a great line. Let me be very clear on that. It was very funny, huge applause, and really nailed home a point. There is a place where jailing your political opponents happens all the time, and that place is various tribal nations around the globe, particularly civil war laden nations like in Africa. where you just go ahead and jail your political opponents after you beat them. And then you shut down that opposition and you create this cyclical feud that goes on and it escalates. And so that's where I want to avoid being. Now, of course, Trump didn't go after the Clintons criminally. Yeah. It ended up being just a great line, which is good. Although I think
someone somewhere has to explain to me, because the left keeps calling Trump like a fascist and authoritarian, and someone somewhere has to explain it to me, because if Trump was truly
he's the worst one.
If he was truly authoritarian, if he was truly looking to, like, you know, take over the Republic and start, like, you know, the 1,000-year reign of whatever, one would imagine that the current coronavirus issue would give him quite a shit ton of pretext to be able to do that, and the rioting and looting would give him a shit ton of pretext. So, like, if he was really interested in being this authoritarian fascist, you know, 1,000-year reign of whatever, why isn't he doing that? Why isn't he commandeering the states and sending in the troops and using the CDC and taking over the health authority and locking down everyone and putting troops in all the streets everywhere? I mean, what am I? I mean, I appreciate I'm a conservative. I appreciate I'm a Republican. I appreciate I'm a biased. But they keep using these terms, fascist, authoritarian, and I'm like, what am I missing? What he's an enemy of the press. Well, he's a really bad enemy of the press, because last time I checked, they still write shit about him every single day,
constantly.
Where is he locking up the press and seizing their printers, and taking away their internet and locking up their journalists en masse so they can't write anything about him? He's an enemy of the press. He's a really bad one.
Yeah, he's a terrible fascist.
What am I missing, Nick? Help me out.
I don't know. See, that was the main thing in 2016. It's why I didn't vote for him, is because I thought he would do a lot of the things he hinted at doing. And I was like, oh, Christ, I don't really want someone who's like, I hate the press, but I don't want a president to jail them either. You know, I don't want federal troops somehow enforcing local laws. I don't want these things going on. But then none of it materialized at all.
Yeah.
In fact, it's been rather tame. So that's good. That's good for me.
And also, he hasn't started another stupid war.
Not yet.
That's good.
Yeah.
Right. I mean, we got through an entire presidential administration without starting a new war.
It's
I didn't even know that was possible.
It's like the first one.
Where are all my anti-war leftists at? That's what I'd like to know right about now.
It's like the first time that's happened in a really long time.
Yep.
In a very long time. But yeah, it's I don't know, man.
Did you see the commercial that the Lincoln Project released today?
No.
Or yesterday?
Which one was it?
Did you see this one? It was okay. It's so great.
Is it
it's so cheesy.
It's not the abortion one.
A mother is going into the bedroom of her young child, looks to be about 8 or so, and wakes up her child and says, "You wanted me to tell you the results of the election." She says, "Who won?" She says, Trump won." And then the 8-year-old kid says, "I thought you couldn't be president more than twice." And the mom says, "You can now." I'm like, vote. If you'd vote Trump, you'd ever get rid of her. I'm like, if Trump is this authoritarian fascist, you know, dictator, he's doing a really bad job of it. He's letting the states implement health policy. I mean, what was he waiting for? COVID seems like a pretty good reason, you know.
Yeah.
The Democrats have been screaming at him for not doing enough.
Did you see
not instituting these massive mandates? It's like I'm confused.
Did you see
things to make sense?
Did you see the commercial with the mom and the daughter driving, and they get pulled over, and the cops are like, "Are you pregnant?" And they drag the girl out of the car. It's like, "Yeah, get her. She's going to abort that kid. Abort her instead. This is terrific." I was cheering on the cops for once in my life.
Yeah, so I mean, Smug Eagle over here, who says once we abandon the rule, rule of law, we never get it back. I'm like,
has he ever?
I don't know what screen you're watching over here, but man,
has he ever heard of Abraham Lincoln? Like, because he abandoned the rule of law quite dramatically in several places and then gave it back. Like that was the big thing that he did, was he gave it back, and he decided, not to do a bunch of things that could have resulted in further war.
And I don't know if you got that far into my video, but I did note there seemed to be an inherent contradiction in Devin's argument, because he says, once you lose the rule of law, you never get it back. So don't vote for Trump because we'll lose the rule of law. But I'm like, wait a second. We already did vote for Trump. And if voting for Trump means we lose the rule of law, and if losing the rule of law means we never get it back, then it's already too late. So what are you even talking about? I'm confused.
So now, logically, we must vote for Trump.
Yeah.
Forever.
Yeah.
Because we can't get it back. So Devin just advocated voting for Trump in perpetuity.
There seemed to be a logical contradiction in here that I couldn't quite square this circle in my mind.
Well, look, you can't expect too much from Devin. He was too busy. He was too busy working the mechanism of law school to learn anything.
And then like the one that really probably the one that really irritated me the most of the whole thing, and there were so many of them, but the one that probably irritated me the most was the Trump hotels and how that's like a unique point of corruption for Trump. Because I don't get it. Because if the idea is that people are staying at Trump hotels in the hope that it will ingratiate them to him, I'm like, well, okay, but your average member of Congress does $5,000 VIP dinners,
right? Which is way more than a $300 room at a Trump hotel.
The dinner's not costing $5,000. So what are you really paying for? I mean, when you go to the Trump hotel, you're getting a room which has a market value, and it's a nice hotel. And also, incidentally, for what it's worth, because maybe people won't know this, DC has surprisingly few nice hotels. It's like the Watergate and the Trump Hotel, and that's about it. You would think that there would be nicer hotels and up-class hotels. It just isn't true in DC. So it's probably the nicest hotel in DC. I've been there. It's really nice. But you're getting a really quality experience. And it's also really convenient because it's right in the center of downtown DC. So you're getting this quality hotel, quality experience. You're paying a market rate, and you're getting it. If you go to a $5,000 dinner, the dinner's costing $2.50.
Yeah, you're getting like a chicken Kiev from Sam's Club.
So if the idea is that Trump is becoming corrupt because people stay at his hotel, how is that not true for members of Congress? And why is Trump somehow uniquely subject to some special corruption because he has hotels, where if he didn't, he'd just be hosting 5,000 dinners like everyone else? It's like, I don't quite trace the logic of this. Look, and that confused me.
I actually covered this on my live stream. It was I think it was while I was yelling about Legal Eagle. But when you stay at a Trump hotel, and maybe you don't know, I don't know. I know this because I've done it several times. When you stay at a Trump hotel, you actually get a personal visit from the president during your stay. And he shows up, he says, "Thank you, marvelous, fantastic. I hope you're enjoying the beautiful property. We have to know what can I do for you as president of the United States now that you've stayed at my hotel? And if you could make it very quick, I have 1,000 other rooms to visit tonight." That's actually what happens. You would know that if you stayed at a few more of them. I'm sure he just missed you while you were there. But no, it's great. The emoluments clause is funny also because if I'm not mistaken, the original idea behind the emoluments clause was not that there would be a business interest that would be this attenuated idea that someone paid money for a product that you sell, and therefore you got some residual amount of that, minus costs or whatever. You got some amount of profit, and therefore you were beholden to them. It was literally the idea of holding a position in a foreign state from a foreign government that was paid. Like the emoluments clause, if I'm not mistaken, was you can't be president of the United States and the Secretary of State of France at the same time. Or a foreign ambassador of Uganda or something. That was the idea.
That was definitely part of the original idea, and in the original, in the early days of the Constitution, that was a real threat. They might offer you to be the Duke of Burgundy or something,
right?
And that might look pretty good. So yeah, that was definitely part of the original point, but it's like because Devin says, well, these business dealings open Trump to special corruption. I'm like, how does that exactly work? First of all, quite a few members of Congress have businesses outside of Congress. There are quite a few business people in there.
Right.
So is it not true for them? Second of all, how's it not true for all the $5,000 rubber chicken dinners? How's that not a thing? The logic of it, I know I'm using the wrong word there. That's exactly the problem. The logic. I recognize the problem immediately. I try to follow it through and I can't make it work.
Yeah.
I'm sorry. I'm trying to think here.
No, it's fine. It's very confusing. Look, Devin's a special boy, and he has created a monstrosity. And what I hate about it is that he acts like his logic.
I think you and I need to create a monstrosity. We need to get some suits. We need to shill. I think it's.
I'll buy a bookcase full of fake law books. Like, I'll just go to all the law students and can be like, "Can I just have the binding of your book, please?" No, I'll fill it with a ream of printer paper. It doesn't need to say anything. I just need the binding. I'll give you $2.80.
Yeah, I don't know a lot of people who are using the books anymore. I think that yeah.
He has such a nice set of them, though.
Yeah.
Do those look like the books to you, or do you think it's a facade?
Yeah, I'm not sure. I'm not sure it's real. I think it might.
They look a little weird.
Green screen.
Yeah, they look a little weird. Now I'm like, why would you have? I mean, that collection of books is $15,000.
Yeah.
If it's real, so I can't imagine like your set being $15,000 and not having like a live stripper on it, because that's if I was having an expensive set, that's what I would do. But I think that would increase my credibility. I don't know.
I don't know. Some people suggested I should get a green screen, and I just don't really quite see the point for me. I don't know, but I think it's fine.
Yeah, it's a weird thing. I don't like it. Well, I don't like him at all. I don't like anything about his channel. I never have. When I first saw it, I was like, oh, look, another law YouTuber. Legal Eagle explains how to get away with murder, the show, and why it's wrong. Well, I know why it's wrong. I watched it. It was just ridiculous. The entire premise of the show was ridiculous. And that's all he basically said. And it was like, oh, okay, so this is nothing. You do nothing. You do nothing for anybody. Thank you. Great.
Well, he missed one because he probably wouldn't know, but I would know because I'm a patent lawyer. But he covered the first episode of the show Suits. And in the show Suits, this guy comes in basically his first day as an associate, and his senior partner or whatever says to him, our client needs to file a patent application. Go and figure out how to do it. And I'm like, no, you can't do that. You need to have a special license for that with the Patent and Trademark Office.
Right.
And presumably his senior partner would know this, especially if they do any patent work.
No,
you can't just pick the random associate off the line and be like, figure out how to file this. I'm like, the patent office will not talk to you.
Yeah.
And so like that whole thing was just a little point where he failed to make that point. I was like, okay, well, I know this. Is like, yeah, no.
Did you see when he accused was it MatPat or Markiplier? It was MatPat, I think, or Markiplier, I can't remember which one, of stealing his Fortnite dance analysis.
Oh yes, I remember that. Yeah.
My favorite part of it is when he goes, I don't know, doesn't that
MatPat, I'm pretty sure.
Yeah. Doesn't that sound like a lawyer to you? And then he starts going through, and then he's like, now here's where he disagrees with me. I'm like, he didn't steal your analysis if he disagrees with you, you weirdo. That's the whole problem with your argument. You broke down internally and failed to recognize that if he was stealing your argument, he would steal your conclusion as well as a layperson. But he didn't do that. And then I love that MatPat, which is a channel with like 4 or 11 million subscribers or something.
Yeah.
He comes in and he's like, I just talked to my lawyer about it, and that was the analysis. It's like, that's why it sounds like a lawyer. I'm like, you dummy.
Because I talked to a lawyer.
It's like, you think a 4 million subscriber channel doesn't have like a lawyer they can talk to? They make more money than the Roman Catholic Church at that point. They've got a lawyer. They've probably got a staff.
I want some of that 4 million sub money. I don't know if we need to play some Among Us or some Minecraft or what we need to do, but we need to get some of that 4 million sub money.
I'll tell you what we can't do. We can't talk about Amy Coney Barrett. We can't talk about transgender toddlers. We can't do it. It's over. That ship has sailed, buddy.
I just have to change every opinion I have.
Yeah, you have.
Why are these mean great grandparents not respecting the transgender rights of the cuties?
No, you're wrong. You can't.
A word I use very deliberately in that sentence.
It's not changing your opinions. It's taking your opinions into the back room and murdering them all, and coming out and talking about literally nothing important ever again. That's all it can be. It's like, let's talk about cat videos. That's let's steal someone else. Okay, you're a patent guy, IP guy in general.
Yes.
Yes. Have you seen the recent stuff? This is, if you haven't covered this or haven't seen it, you need to look. There's a guy named Nicky Acevedo or Avocado or something, and he does like these mukbang videos where a person sits down and just eats just a ridiculous amount of diabetes, and then and this other person just took his videos and like was uploading them with very minimal commentary in text, and that minimal commentary was stuff like, oh, look what he's doing, wow, that's a lot of food. So it kind of might not be transformative, might be, but that's a hot legal subject right now involving some pretty big players in the scene. So you might be
what's
uniquely
transformative and what's not.
Yeah, in this context, in the context of these videos, because
I was trying to figure out if I wanted a piece of the Omegaverse controversy with fan created copyright. I was like, do I want a piece of the wolf porn? I don't know.
Yes, you do.
But I was like, yeah, that could be a thing. But yeah, I'll take a look at the transformative use. It's as we all know, it's complicated. But yeah, the minimal text is probably not cutting it.
If you want to, but I'm saying if you want a video that I think will land well and be right up your alley, Nikado Avocado is the guy's name. He's on Twitter. He's threatening a lawsuit right now over this stuff. It would be perfect. It's also disgusting because it's a man just sitting there chowing down on grease or whatever. But it would be good, and it's a popular topic. So
all right, well maybe I'll get a piece of that, and I'll get a piece of the Omegaverse wolf porn.
Wait, I thought it was Subverse. Are you talking about the Tim Pool thing?
No, that's a different thing. The Omegaverse is because it's alpha, betas, and omegas. Because alpha, beta, in that idea. So we got alpha, beta, and omega in a tri relationship, and it's gay wolf porn.
Oh,
it's a whole thing.
I don't know. I don't know anything about that.
There's controversies with people suing people over the rights to the wolf porn. It's a whole thing. I
just know that I'm alpha and Copper Cab is beta. Yeah. Take that, Copper Cab. Yeah. Okay. Well, let's do the chats and wrap up the show. We're coming up on 2 a.m. Which is that's an appropriate time.
No, I'm way past my bedtime, so I'm into high energy mode at this point, so it's fine.
Okay, good. Bad Vibe says, okay, can the Supreme Court take a case sua sponte of a fresh law that is passed by Congress and approved by the president? Only if they have original jurisdiction over it. Yeah. And then, typically no is the answer. Peter Bemis says, Pat Court withhold state funding unless MPVIC lawsuit, court affirms legality. Undocumented immigrants given voting rights, one-party rule. Don't think this is a slippery slope. I think it's the plan. That's what Peter Bemis says. You know, it might be. It might be. Who knows? It's somebody's plan, I'm sure. Whether it's the plan is always a question. Crusader Saracen says, have you seen Obama as he finally campaigns for Joe Biden? I don't know what's more cracked, his mental state, his ego, or his voice. I think the past 4 years of Trump just broke him. Yeah, I did see that. Did you notice his voice was
did see that, yeah.
cracking like crazy? And I always forget how massive his head is compared to his body.
Nice.
It reminds me of.
I have a big head. This hat had to be custom made for me because my head's so big I couldn't get anything off the rack.
Yeah, but your head looks proportional to your shoulders. Whereas, have you seen So I Married an Axe Murderer?
Yes. Right.
And he's like, it's like an orange on a toothpick, right? Like that's how I see Obama's head. It's like an orange on a toothpick. You know, it just looks way too big for his body. Crusader Saracen says, I think Chauvin is bone no matter the race, composition of the jury. Blacks will convict because he's a white cop. Whites will convict because that effing cocksucker got Minneapolis burned down with his smug face in a moment of retardation. Might be the way it goes. Night of Hope X says, fist bump for reminding everybody that this is the way the left wants things to be. They want to control your ability to hold your positions in public and impart them to your children. I'd like to add, if we vote for this insanity, we get what we deserve. Malik Foxon says, eating good tonight for the first time in a while since I got a new job. Hey, awesome.
Nice.
Finally off the top ramen diet. Hey, don't diss it. Tonight, it's 2 Cornish hens stuffed with beef stuffing. Also, I know I said I wasn't going to be around much until the end of training, but sleep equals weak. Snack Sheet says, I live in a heavy pro-castle doctrine state, and I have multiple trespassers will be shot signs. If I do have to shoot someone, how covered am I? Not at all.
Not very much, no.
Yeah, you are not allowed to shoot someone for trespassing on your property. 99% of the time. They have to be imminently committing a felony, of which trespass is not in any state that I'm aware of felony. Right. And not that's only in the heavy castle doctrine states. And sometimes those felonies, if they don't put you in danger, depending on what state you're in, are not sufficient to justify lethal force. So you got to check on your specific state. Bad Dragonite, for Uncivil Law and Nick, what are your thoughts on New York Governor Cuomo closing New York's double jeopardy loophole, authorizing the state to prosecute those pardoned by a president? Great show tonight.
Oh, I mean, that's not a problem anyway. There was a Supreme Court case on that 3 or 4 years ago dealing with that issue. It's a separate sovereigns issue. It was never a problem to begin with. The state government and federal government can both prosecute you without creating a double jeopardy issue because they're separate sovereigns.
Right.
So it was never a problem at all.
You just have to have commit a crime or be alleged to have committed a crime that fulfills the elements of the state crime and the federal crime. And the state would have to have jurisdiction over your actions within the state. So, that was a weird sort of thing that he did because it was weird because it was unnecessary. AGK says, I hate to admit it, but before I came across your channel, I watched Legal Eagle. I'm thankful you pulled me out of that dark hole. Also, would you consider stream clipping the Legal Eagle rant on your channel, please? Cheers. I would, but it was like an hour of my vein popping out. I don't know. I'll have to see. It'd be a long clip, but it might be worth it. Stargate 404 says, Ricada, I got my 1L law school exams a week after the election. I know you're one of the few who know my pain. Yeah, that's true. I think my 1L exams were in 2012. So good. Yeah. Also, what are your thoughts on Legal Eagle? I checked out after he mounted a legal defense of Captain Marvel beating and stealing. Then he went full TDS. In a recent live stream, I gave very intense thoughts on Legal Eagle, and I stand by every single one of them. Cesario JPN says, I can't wait for Billy Mitchell to play the Donkey Kong game in court to prove his skills and win his lawsuit with Twin Galaxies. That would be great. Sega Shooter Games says, there needs to be a permanent limit on Supreme Courts. The fact that court packing is a thing is so scuffed. Yeah, that is a way to resolve this, is just to set the limit of the Supreme Court with a constitutional amendment. But we're so far from any constitutional amendments right now that it's crazy. We're too divided.
The lingering Equal Rights Act is still floating out there on terms of whether or not it's ratified or not.
Yeah.
So someone still has to have that fight. I'm kind of secretly wanting it to become a constitutional amendment because I think the left is going to hate it. Because I think it's going to wind up benefiting men way more than women. I think they're gonna rue the day that all these people are like, feminism now, pass the ERA. I'm like, I don't think it's actually going to work that way when it's implemented, guys. I don't think you've thought this all the way through.
And that's the danger of permanent changes like constitutional amendments versus just legislation. If they're not carefully drafted and heavily debated, you have hell, the ones we have were carefully drafted and heavily debated, and we have a freaking mess.
That's right. How complicated can the First Amendment be? Well, how much time do you have?
Right.
Yeah, that's right.
Okay, we've got Thane Cotter says, so you're saying you have standing to sue Twitter for misrepresenting their product? I don't know. Maybe. I might. Anyone who is banned might. But it's still a really tough case because of Section 230. That is just a complicating factor in any civil litigation involving a provider of online services. And we'll see what the extents of it are. If they go ahead and undo Section 230 or effectively gut it or rewrite it to get rid of otherwise objectionable or something like that, there's a real chance of some big time lawsuits happening very quickly. Austin M says, infinitely divide Texas until we can elect Jeb. This reminds me, my daughter, she's young and she plays violin, and she does the Jeb Bush when she practices violin. Like, she'll go play a song in the next room over, and then she'll come into the room we're in and she'll say, clap. And she'll wait for people to clap so she can bow and then walk back into the room to play another. She is full Jeb. The Elmo, welcome to paralegal status. O.O retracted your message, but thank you. He also says, Nick, get a look at this guy, Somberg, SombergLaw.com. Oh, no, I don't want to. I've looked at him. Tony Neves says, Floyd's death was bad, but what's worse is Rep. Sheila Jackson Lee comparing Floyd to Jesus on the cross. You could have just stopped at what's worse is Sheila Jackson Lee.
Funny.
She's awful. Mario Carter 13 says, if Hunter Biden took interest in HV, what you do? Oh, no.
Kid from earlier. That's
It took me a second to get there. I was like, HV, no. The cameo says, I think Sargon had something to say on this issue. Come on. Depends on the child, I think was the something. Doug says, hey, Nick, very off topic, but looking for advice. Voting to retain judges in Utah right now. How accurate are the blurbs about judges on .gov site about their performance? JPEC survey responses. Man, I don't know. I think the only accurate way to look at judges is to really independently go research their opinions, and nobody on earth has time for it. What do you think about that?
Yeah, I think that's about right.
Bad Vibes says, Ricada Law, you missed my second chat. No, I didn't. I said it, but the stream hiccuped. So here, I'll read it again. He said, I noticed something. Why is biological family classified as foster parent? Biological family should be beyond those standards. I think it has to do with the state providing assistance to the foster family is the main reason the classification exists. But the other reason is anytime the state has custody of a child, they have to justify how they determine where that custody goes. So that's the issue, and creating a separate class would maybe run into issues. I can't, I don't know what they would be, but I can imagine there would be some. Is a second cousin or a great grandparent closer? In my family, a second cousin, or a third cousin or first cousin twice removed or whatever might be closer than a great grandparent, and someone else it might be different. So I don't know. Automata says, I have it on good authority. Carl Jobst is an absolute legend. Really looking forward to that show. Mars Ultor says, when the F are folks going to admit that regardless of social trends, when it comes to law, the slippery slope is called precedent?
Yeah, really, no joke. I could not agree with you more, because that's one of my favorite or least favorite things when on my channel. It's like, it's a slippery slope. I'm like, no, it's just precedent. It's a brick in the wall. It's one more step along the way. That's like how the legal system works. I'm tired of explaining it. I'm running out of words.
Nexie says Masterson is 40 today. Tell him it's okay to be old, but it isn't. It's not okay to be old. Mario Carter 13 says, ask Jeff Sessions how recusal turned out. Chris French says you should look at the election fraud in Harris County, Texas. No, there's no election fraud in Harris County, Texas. That's where Sheila Jackson Lee is. Mario Carter 13 says alpha equals top, omega equals bottom, beta equals no one cares, lol. CJ says have the racket links cut cardboard strips out of green and burgundy construction paper, draw gold bands, and tape them to old hardcovers for your shelf. Venticus Prime says, Kurt, how big is your head? I got over 25 inches here.
I'm not sure in inches, but my hat size is 8 3/8.
I don't know what that means.
It's about, I'd have to convert, I think it's 26 inches because you multiply by pi, but I'd have to do the math.
I don't do math. I'm a lawyer. Othimer says, Uncivil Law, great to see you back with the Grift Lord. Voted today. Everyone should vote, even if only to mess with the pollsters and talking heads. I might do early voting. I don't know. I gotta see. Just because I might have time, and I might not have time as much time on Tuesday. R.W. Bimby says, will Dems still demand expanding court if Trump wins? Well,
yeah, really, yeah. That'd be good, yeah. Hey, you guys want to pack the court now? I'm all about it. Yeah, really.
Keck7 Go says, has Uncivil Law seen Legal Eagle's video on Rome's fall? Yeah, Keck, his video is what inspired my my rant. Yes. And you should all go watch it because it's very good. Go check it out. Angry Baneling says, Peacock really not doing the big brain panel? No, he's not. He had to back out. Sorry. Doug says, thanks, man. I feel secure in my 16 totally uninformed decisions on Utah judges. Thanks for the entertainment. Look, here's what I know. Here's what I know. In my state, there is a woman running for Supreme Court Justice. Her name is Michelle McDonald. She's ostensibly the Republican Supreme Court Justice candidate. And I will never, ever in my life vote for Michelle McDonald for Supreme Court. She was the first lawyer I went against in an actual case. I absolutely devastated her in that case.
Nice,
it was really embarrassing, not because I was any good at what I was doing. I wasn't. It was the first case I've ever done, and I was on my own. I was literally learning as I went on how to do this, and I beat her at every turn because she was a terrible, terrible lawyer. And she would make a terrible Supreme Court justice. So other than that, all of my decisions on justices are uninformed in the state of Minnesota. But for her, I will never vote. And if she gets elected, it would be a travesty. Cars in Depth says, will any supporters of mail-in voting mail cash? I hope not. Angry Baneling says, please vote for Orange Man this time. Win bigly. And then, here we go. Xander's Rant says, Lindsay Ellis did a video about Omegaverse and getting DMCA takedown from the person who is suing. Also had Legal Eagle cameo in her video with him telling her what the law says, even though the joke is he's just reading a script that she gave him. So there, I didn't watch that. I heard about it, or I saw a comment that he was in her video. I don't even know who Lindsay Ellis is, but yeah. All right, man. That's the chats. Do you have anything final to add before we buzz out of here?
We still on for election night Tuesday?
Yes.
That'd be cool.
You are invited. I will, when I figure out the exact details of the show, I will pass them on to you. Right now, I'm thinking it will start around 5 or 6 p.m. Central Time, and it will go. Guys, we are likely going to have like a 9-hour stream that day. So it will be going, and I'm inviting many people to hopefully just kind of pop in for a while, pop out for a while, pop back in. So there are invitations out. I will be on here. I believe Ty will be on for a while. I will have Lost from the Discord in here. I think he will be in studio with me, and Soder maybe as well. So Q will probably be invited on the show to pop in if he wants to. But it's going to be very open. And there's some other people I've invited that you know their names, but I'm not going to say them until I get confirmations. But there's some other very big prominent YouTubers talking about election stuff that I've invited to hop on the show if they have time. So yeah, it should be fun. We're just gonna be sitting around laughing, having a good time. So
cool. Well, I've had fun as always.
Yeah, man, it's always a blast, and we'll do this more, of course. And I will see you on Tuesday night, guys. Come over to Twitch, Maximum Overdrive tonight.
Classic.
And then we're gonna follow it up with, what is this thing called? Storm Swept. Which will be really good for a second Twitch movie. All right. Well, yeah, if you want to hang out for just a second, like, I like to say goodbye off stream. Thanks, guys. Have a good night. No outro today. Hard to do with a guest. But go check out Uncivil Law. His link's in the description. Subscribe to him. Catch you guys later. Peace. Peace.